Good morning. This is the New York City Board of Standards and Appeals Public Review Session for September 12th, 2018. We'll begin with new cases. Item number 1, 6713A, 945 Zariga Avenue, the Bronx.
Okay, so this and the following case travel in tandem. This first case is a request by the Department of Buildings to rehear based on new evidence. The second is a remand from the court directing us to reconsider our decision in light of the board's decision on another sign case. Because Department of Buildings' new evidence case could have the effect of rendering the question on remand moot, we should review the new evidence first and allow the property owner to respond to that submission. That submission includes several photographs that we had not seen in prior hearings, which were provided to DOB by the New York State Department of Transportation, taken on June 28, 1978, June 18, 1981, May 7th, 1985, October 22nd, 1990, and May 16th, 1995. And I should say those dates are what's stamped on the photograph. So the last two of which in 1990 and 1995 show the sign in place. The prior three of which from 1978 to 1985 show no sign. So tomorrow I would move to permit a rehearing by DOB based on new evidence. And to the extent that either party would like to discuss this evidence at that hearing tomorrow, they should be permitted to do so, because that'll help us move along with the proceedings. So oftentimes we'll say we move to allow for a rehearing and then we calendar it for another date, but I don't think that would be an efficient use of our time with the next case. So we'll, if the two parties want to discuss the factual information on the rehearing tomorrow, they should be allowed to. So we'll open it up as a hearing.
And we'll still schedule another date where they would submit everything in writing, basically?
Yeah, so they'll submit a response. Both sides will submit. Obviously, in this case, the property owner hasn't had a response at all, hasn't had a chance at all to respond to those photographs. So they, of course, should have an opportunity. Okay. Did you call the second one
No, I
also?
did not.
No. Okay.
Item number 2, 6713A4, 945 Zariga Avenue, the Bronx. This is a remand back from the court.
Okay. So in this case, the court directed the board to review the materials that would establish that the 1,585 square feet of space leased by Philip Morris was in fact being used by Philip Morris for some purpose sufficient to establish it as a use to which the sign would be accessory. As I recall, that Zariga case went on for 5 hearings, that case that is being remanded to us, and the discovery by the board that there was a space lease and a sign lease running in tandem to, quote, legalize the sign as an accessory business sign was not the result of the owner revealing this information, but rather of being, quote, found out by the board after the board's careful reading of the leases. The owner's defense to that discovery was that the lease documents were all a ruse intended to trick DOB into allowing the sign to continue as a permitted accessory business sign. The board's decision not to request additional information on the actual use of the space, which the board is now being chastised for by the court, arose from its position that an owner should not be rewarded with property rights achieved through submission of what it later claims to be fraudulent documents to a governing agency. I think the court here is asking us, perhaps, to ignore this fraudulent behavior and dig into the depth of the fraud. I'm not sure that that is the job of the BSA. If the owner wants to brief the board on the effect of fraud on a contract, or an application to a governing agency and appearance in hearings before another, I would be very interested to read that. The court needs more. The court also asked the board to clarify in its resolution on a number of issues, which we must do because this is being remanded. So the court needs more information on what it means in arcane zoning and building code parlance to, quote, legalize a use. We can provide that ourselves, and we can discuss it in hearing, so it's on the record, and should. But I would like DOB to brief this subject, to give a clear explanation of this terminology and put it in the record, and just to throw in a brief description of a legalization. The idea so that it's in our record, the idea is that a property owner constructs something without permits and without approval from DOB in the Department of Buildings in any way. And then subsequently, the Department of Buildings goes out and discovers that illegal construction, so the construction is built without permits, and then issues violations. Because the construction's in place, the property owner must move to, quote, legalize it, make it legal by obtaining permits that show compliance with zoning and building code. So in this case, in the Zariga case, the subject of legalization was that at a time in what I guess was the late 80s, they received a violation for their sign, and in an effort to remove the violation, therefore legalize it, they had to apply for either an advertising sign or an accessory business sign. Those were the only two options. And it seems that they were not able to make the case to the Department of Buildings that they had a legal advertising sign. So instead, they filed to legalize with an accessory business sign and showed the lease. Maybe they showed the lease. We don't know actually what they showed DOB, but they represented to DOB that this was an accessory business sign, that the sign that they were going to mount was accessory to the use in the building. And we don't know what kinds of materials were shown to DOB for that. Okay, we also need to clarify for the court's benefit the board's reference to the city planning report about illegal behavior of outdoor advertising companies in attempting to work around the zoning resolution's clear prohibitions against advertising close to arterial highways. And we need to be sure to include a copy of the city planning report in the record. The significance, again, for our record, so that the court hears this, the city planning report was written about 10 years after the subject site, so the subject case. So when the subject sign received its accessory business sign permit, so was legalized as an accessory business sign, that was about 10 years before city planning and the Department of Buildings started to realize that there was a lot of this so-called sham lease activity going on. So lots and lots of advertising companies were renting space in buildings and then mounting signs above the buildings and saying they were accessory. And somehow or other, the Department of Buildings started, and city planning started to realize that that was being used as a way to basically have advertising signs, not accessory signs. And so they started to look into changing both the building code, the sort of the rules and regulations, the operations at the Department of Buildings, and the zoning resolution. So the city planning report actually recites a history of this to indicate that, for instance, city planning believed that the zoning resolution was very clear in prohibiting advertising signs close to arterial highways, but that the advertising industry had found ways around it, and so it needed to crack down even more in how it was both how Department of Buildings was regulating the signs and how city planning was describing what's a permitted sign. So that's why that was discussed in our record, and we will include a copy of the city planning report in the record. It's true that sometimes we find things and they're not submitted into the record because for us, this is our arcane special knowledge about the zoning resolution and the history of how zoning is modified. So then We also are being asked by the court let's see, we need DOB actually to respond to the court's concern that the Department of Building has overlooked the so-called, quote, sham leases in the past. The board will conduct its own investigation of its prior decisions on the subject, and actually has, which I'll get into in a minute. But just to go back to what I was saying before, DOB hasn't exactly overlooked the sham leases. At the beginning, it believed that those leases were legitimate. That's why it issued those accessory business sign permits. And then, over the years, discovered that this was actually some kind of like an operation, and then decided to crack down by creating procedural policies. And then, as to whether the sign is accessory to the building's principal use, which is again something discussed by the court, which I believe is the court's reading of the phrase. So a sign is accessory to the building's principal use is how I believe the court is reading that phrase. I don't believe that's correct reading. The accessory use that is referred to has to be related to the principal use to which it is accessory, as opposed to being the principal use itself. So there can be many principal uses in a building. The accessory use merely has to be accessory to that principal use. So, and the signage regulation, so you can have, so for example, you could have 10 uses in the building and 10 accessory business signs on the building, as long as they're accessory to the principal use in which they're, to which they relate, right? So the sign regulations actually bear this out with respect to accessory signs under section 32-64, which states that each establishment, so each business, is allowed its own accessory sign and is treated as a separate zoning lot for that purpose, so that if there's a maximum of, say, 150 square feet per zoning lot, each establishment gets 150 square feet. And so the question here should have been, was there a use on the site to which the sign was accessory? That's the only question. And there is no requirement that there be an active use on the site either. That doesn't appear anywhere in the zoning resolution. So it doesn't have to be a sign that directs attention to an active use. That's not the language in the zoning resolution. If the Department of Buildings later clarified that in its own rule-making or in its policy notices, that's a different subject. But we're looking at what the text said at the time that this accessory business sign was permitted, right? Then, the court also asked us to look at this case, the case we decided, in light of the board's decision in it's case number 24-12A and 147-12A at 2368 12th Avenue. That case was for 1999 sign permits at a time when the Department of Buildings sought via its own operational policy and procedure notice number 10 of 99 to take control of the accessory use situation and to clarify what type of leaseholds could support accessory signage. This was coincident with city planning's amendments of the zoning resolution that are referred to in that city planning report that we were talking about earlier. And to clarify, where the CPC report discusses the, quote, creative efforts by the sign industry to circumvent the regulations. In that case, in the case of 12th Avenue, the appellant argued that the sign was accessory in spite of the Department of Buildings' determination that it didn't meet the requirements of the policy notice. So, yeah. So, it's a very easily distinguishable case because it happened 10 years after the subject case when Department of Buildings had shifted its policy and started to determine that warehouses cannot be a location on which you've got an accessory business sign. And that's one reason why, in that case, there was so much analysis of the facts, because the owner was trying to establish that the sign really was accessory. So they provided a lot of information, and DOB debunked that by saying, we never would have allowed this had it not been, I think it was a self-certified application, we never would have allowed this sign to be up because we had changed our policy and we knew that this was not an accessory sign. A prior case, case number 45-96A, decided in 1997 concerning a sign for cigarettes at a gas station convenience store, struggled with a similar question that resulted in Operational Policy Notice 1 of 97 from the Department of Buildings that was subsequently superseded by the above referenced Policy Notice 10 of 99. So there was a, and I think that, I forget exactly how the decision was on the cigarette case, but we can fill that in. The subject sign and the subject leasehold predate these policy notices by 10 years. I don't think it is proper to apply policy initiatives such as those policy notices retroactively. In 1988 and 1990, when the subject permit was approved, Department of Buildings believed these leases were legitimate or would not have accepted them to, quote, legalize signage as accessory. Having found out about the scams, they sought to eliminate them by they being DOB, by requiring more proofs of the accessory nature of the signage and to clarify the meaning of, quote, accessory signage in the zoning resolution. But they didn't do that for 10 years, until 10 years later. In 2013, the Board of Standards and Appeals decided a similar case to the subject, case number 68-13A at 330 Bruckner Boulevard, where an accessory sign permit had been obtained in 1981 based on a lease for space in a building on the zoning lot. The BSA agreed with DOB that the outdoor advertising company's subsequent claim that the lease had been a sham and the sign, in fact, had always been advertising was unsupported by the evidence of the accessory sign permit. So I think, actually, so the court, in a little bit of admonishing BSA for not having held to its own precedent, was given the precedent of the 12th Avenue case, which really took place during a totally different time period. The facts take place in a different time period. They were not directed to much more relevant precedent, which is that 68-13A Bruckner Boulevard case, which is exactly the same situation as this one, where the BSA and DOB looked at the materials that had been presented to it in the 1980s and said, you made a representation that this was accessory. We believed your representation. We issued a permit. The permit is a valid proof that that was what the use of the sign was for. So I think we continue to be consistent with precedent.
That was New York Bus Company?
It was. Yes.
Correct. I remember that.
And she remembers it. Okay, any other comments on this?
Well, I don't want to get into it too much, but there is substantial case law with regard to estoppel and the evidentiary value of a prior sworn statement, such as one made in a permit. And
Do you pull your mic closer to you?
sure, I can move closer to the mic.
Yeah, both.
And I'd like to see that briefed, and I'm planning on going into a bit tomorrow if we're going to have some substantial discussions about how the applicant's now turning back from his prior sworn statement, and whether or not he should be stopped from doing so.
Okay, is there anything, I know that council has done a lot of research on this. Does anybody want to add anything?
I just wanted to add that though Commissioner Otley Brown recalls 6813A, and you've mentioned it on the record, we should circulate it to the rest of the commissioners so they can review in advance
Yes.
of the hearing tomorrow.
Right, okay. Okay.
Item number 3, 2017-248A, Long Island Expressway at 74th Street, Queens. It's a sign case.
Another sign case. We have proof of service and of notice of hearing to DOB, which is what's required, and also to the property owner. Appellant states that it can prove that this double-faced sign within 600 feet of the arterial was established prior to 1979 and has been used continuously as an advertising sign. Unless I'm missing something, the proofs I saw were nearly impossible to read. So if they want us to come to a similar conclusion, we need clearer submissions. In addition, and I noticed that Department of Buildings, when they were reviewing this, had similar comments, and our own notice of comments over the course of this application said that as well. So it's possible that what they have as proofs are just illegible from the get-go, and then I don't know what to say. In addition, we need an explanation as to the significance of the submissions. So it should be attached is this, it means the following, because I look at, for instance, an electrical sign permit, and I don't know what it's telling me. So there is a timeline provided, but I'm actually not making the connection between the timeline and the proofs because of the legibility issue. So timeline works great when you see Exhibit A, this occurred on this date, this means the following. For example, with the electrical inspection certificate, I can't find the sign in the tax photo, or or in what is described in the list as DOB inspection photos, which are also undated and not labeled. And unless I'm misunderstanding, we might be looking at the recto verso of those images, but I don't know. So they just kind of included them. Am I looking at the back of one, and that's supposed to be telling me the date of the front? I just don't know. There's also a huge gap in the continuity proofs. There is a legible license agreement for a 20 by 60 back-to-back sign of dated January 15, 1976, although the location isn't clearly the same. So we need the applicant to demonstrate that this is the same location. And the lease is a one-year lease renewable for 1 year period, so all that, which is quite rare. I mean, I think most of the time we see sign leases that are long, right? They go on for 5, 10 years, that kind of thing. But this one is sort of very tentative sounding. Maybe we'll take it down next year. Maybe we'll take it down this year.
And the dimensions are wrong.
Yeah.
Right.
I mean, the other thing to point is that there is another sign there, and it's not clear whether these documentations apply to the subject sign that we are reviewing or the other sign. So that there's also that lack of clarity.
Okay, hold on a second. I also didn't see any proof that the lease was repeatedly renewed, which is another thing we often see. Often the OACs have like a roster they keep that shows that they've been renewing and renewing and renewing. There's like a manager who says, sign number 156, renewed, but they didn't give us anything like that. So they need to go through the proofs and demonstrate also how each one meets the criteria under Rule 49 for acceptable evidence, because I also didn't get there. So acceptable evidence for, I'm just reading from Rule 49, acceptable evidence may include permits, sign-offs of applications after completion, photographs and leases demonstrating that the nonconforming use existed prior to the relevant date. And so they should explain how each one of the proofs fulfills the Rule 49 criteria. And in what order, because there's a hierarchy. Okay. Anybody else on this?
Item number 4, 2017-253A, BQE at 34th Avenue, Queens.
Everything's calling everything. Okay, this one, they're postponing because it's a similar fact pattern to cases that we're hearing on November 20th, so we'll postpone this so we hear them all together.
November 20th?
Yeah.
Continued hearing items, item number 5, 13197BZ, 1600 Boston Road, Bronx.
Okay. A notice to immediate neighbors of the upcoming hearing was distributed to those neighbors on August 21st, which is what we requested, and I didn't see any letters in the folder of objections, so I guess the neighbors are okay with this. And I think the main okay with this was the 24-hour operation. That was the main thing I was concerned about. The detail on drawing, the detail number 3 on drawing A250 appears to have been mislabeled as a menu board. I think it is actually the fence along the property line, and we had asked that it be an acoustical fence with an attractive wood stockade fence behind and in front. And I don't see any indication of the acoustic fence. None of the details on that same drawing A250 are keyed into the site plan, so actually you don't know that they exist or where they are. The lumen spread diagram indicates very high lighting levels over the property line onto residential properties. This must be corrected, and the levels must be 0 at the property line. There's some half-hearted landscaping on the drawings that are shown at the fence line and elsewhere on the property. At the fence line, we need a detail through the planting bed to show that the shrubs have adequate planting widths and depths. And all of these shrubs, as well as many others, are labeled, quote, TO for however you pronounce this, Thua occidentalis, arbor vitae, but with sizes of varying heights and widths. So they're from 18 inches up to 6 feet, all in the same designation. That's not how you do a planting schedule. The schedule needs to be more specific about what is planted where, the sizes, the spacing, everything. And along the property lines, for example, this planting should be dense screens. I could tell from this that this was not done by a landscape architect, so a landscape architect should be preparing this plan to ensure the success of the landscaping in addition to being a professional landscaping plan, right? And this applicant certainly can handle it. It's McDonald's. We also asked for proof that excess signage was removed, and I didn't see that. And I still don't see signage drawings showing dimensions by frontage. So there were a lot of things that weren't responded to. Anybody else?
I had additional question on Plan A052. It shows the reservoir spaces, and as I understand it from the documents submitted, there is entrance from Seabury Place and from Boston Road. From Seabury Place, there is space for 8 reservoir spaces, and of that, actually 1, 2, 3, 4, 5, 6 is kind of in the common area. There are 2 strands of entryways. One is from Seabury and Boston. So from both ways, if you count it, there's a total of 8 reservoir spaces. My question...
8 or 10?
It's 10.
I thought it's 10.
It's a total
Well,
of 10,
8
8
+ 2.
from Seabury and 2 from Boston
That's
Road
exactly
in a
my
Y
question.
formation.
That's my question, is that required is 10, it is showing total of 10, but it's 8 from, if you enter from Seabury, and again, if you count it from Boston Road, it's 8.
Well, they were asking to reduce.
What do you mean it's 8? No,
Well,
it's
if
2
you-
from, it's
what I-
10 in total, oh, it's 2 from Boston Road.
2 from Boston Road, 2 from Seabury, merging with 6,
Oh, I see what you're saying. Yeah, yeah.
right? That's how
Okay.
I'm looking at it.
Okay.
My question is, which entryway is used most? And the reason for asking that question is, will it result in backup on Seabury? I don't think that would be an issue on Boston because there's enough space, frontage of the property. So they can, additional 2 cars can back up, but there isn't that provision on the Seabury Place. So I just wanted to know if there is enough space.
We usually require the 10 reservoir spaces, but
Right. But
it's-
typically, we have seen 10 in a
Right,
row.
in a row, but they
Not in a Y
could-
formation.
They could include the 2 on Boston Road. They could, instead of the ones coming from Seabury, they could knock those 2 off and put them behind the 2 that are from Boston Road, and
So-
they'll still fit.
That's
It's
true.
just,
That is
right,
true.
so
They
they
will.
have to show that they
But-
have 10 reservoir spaces, and I think they have, and if we want, we could tell them to take the 2 off Seabury and put them on the Boston Road entrance to show that they fit, that you could have
Which-
10 people in a line to clarify it.
I
But it
agree
is
with you.
clear that they
I-
will be able to fit it
I
that way.
completely agree with you that 10 reservoir spaces will fit from Boston Road. In that case, are we then saying then Seabury Place should not be used as an entryway or?
I don't think we have to say it should be used or not. We just have to show a continuous line of 10. And then because we never say when there are multiple entrances and exits on various fast food places that you have to pick one and only one and the rest can't be used as entrances. We
Right.
just have to show that there is the ability to
Okay.
absorb 10 people on a
Okay.
line without spilling out onto the sidewalk or the street.
That's fine.
And they could demonstrate that.
Okay, that's fine, that works, I understand that. So then if it's an additional set of vehicles coming from Seabury, they're going to merge in with the 10, and you already had the 10 provided from Boston Road.
Right, but they should show the 10.
So
Right.
on the Boston Road entrance. so
Right, add two
cars.
cars.
Okay.
And I do not think it will affect the flow of the circulation and vehicles entering and parking on the parking lot with the addition of those two spaces.
Okay, so the only change to the drawing is to add the 2 cars.
Right.
Okay, on this Boston entrance.
Okay. You have no issue with the hours of operation nor the reduction in parking?
Say again?
You have no issue with the hours of operation?
No, that was
Or
the
reduction
reason
in
for
parking.
reaching out to the neighbors. If they don't care that it's 24 hours, then who else is affected?
But Tony's second question was the reduction in
reduction
parking
in
Parking spaces?
Oh,
from 9 to 8.
I don't, because it's mostly, we're talking about the drive-in, so you're not, and the philosophy being if the drive-in line's too long, then you park. So,
Okay. Thank you, Tony.
I'm sorry, but just to leave this out, there were still other changes on the drawings that need to be made, so that has to do with the acoustical
Oh,
and
yeah.
the landscaping, right? I
Yes.
remind myself that it's not done.
It's not done.
Right, okay.
New cases, item number 6, 93328BZ, 12524 Metropolitan Avenue, Queens. Proof of service has been done?
Yeah, I found both. Whereas there's proof of service of initial application to officials and of notice of hearing to officials for this hearing date. We got, right? Is there, people are looking at it
Veronica.
quizzically? Yeah, I saw it. though. Yeah, right. Because this was noticed for the last hear, for,
This is the third
yeah,
postponement.
yeah.
So there was initial notice for all of them, but the rest of the hearing notice was a separate notice. So
Right.
Proper notice for the hearing was given.
Okay, good, thank you. Community Board recommended conditional approval. They said, supports a request for a 10-year extension of the variance on the following conditions, that the proposed site plan submitted to the Community Board is adhered to and supplemented by the following: an additional street tree is planted on 126th Street, which I think they actually show, in accordance with Department of Parks regulations with respect to tree pit size, et cetera, that the proposed plantings noted on the plans, including those labeled T1 and T2, be maintained throughout the variance period. Thus, any and all plants that wither or die would be replaced with the same or similar plants as soon as weather permits. I actually really like that phrasing. We should adopt that. As soon as weather permits, it gives you a tight timeframe. We have fire department sign off on this. The May 2018 photos show the fence enclosure around the parking area with signage that's not shown on the elevations. It is shown on the plans, it's given numbers on the plans, but the place kind of looks a little haphazard, shabby. They need to show the overall dimensions of the structure on the plans and of the parking areas also. Instead, it's showing the interior dimensions, so it's like 10 feet and 4 feet and 8 feet and like that, and then you have to do the addition yourself. How big is the structure? Out to out. There's supposed to be a trash and storage enclosure, which is not provided. Where is that? That was a condition, in fact, of the 1994 extension. So there's been 2 extensions since, and we still don't see a trash enclosure, so that needs to be done, actually. For planting areas, we need details of the planting beds showing the curbs and dimensions. So this is a part that I find quite very confusing about this application. I don't understand the argument against planting beds in the parking area if you just look at the floor plan, at the site plan, because there's adequate room for in-ground planting if you look at how big those planter boxes are, right? However, and the approved plans show a sidewalk in that location, so there already was an allowance for something like 3 feet wide, or even maybe wider, to be around that planting area. However, when you look at the photos, the fencing is all the way around. There isn't room for anything. The cars are squished in there, and so I don't understand the idea of the planters that are shown on the drawings. There's like a disconnect between the reality of the site and what you can show on a drawing. And when I look at Google Street View from 2017, it shows cars parking on the sidewalk and broken sidewalk curbs, and many cars parked along the western lot line where no parking spaces are delineated on the plans, and more miscellaneous signage on the western lot line fence. And that view by the western lot line fence wasn't provided in any of the photos. It was like turning your back to maybe the ugly stuff. I don't know. And also, the asphalt in the May 2018 photo shows it's in need of resurfacing. And this use is adjacent on all sides to residential uses, which is quite unusual. Most of the time, we have like one residential use, but it's commercial adjacent on the others, so we're only worried about one border. In this case, it's a completely residential neighborhood, so I'd like to know what's the method of buffering this use from the residential neighbors. There's been no effort at all. And also, when I look at the satellite view, I question whether the parking fence enclosure is outside of the property line, because on the satellite view, it extends beyond the front walls of the neighboring houses. And so the housing typology doesn't appear to be that type that's set back from its own property line. So this is really forward of their front wall, so I'm not even sure that they're on their own property here. So they need to provide a survey and show us where the fence is on the survey. Any other comments?
You mentioned the signage, and I agree with you. I mean, based on the site visits, I felt that some of the signage, though included in the drawings, the dimensions are not matching up. So the existing signage either need to be reduced to match the dimensions shown in the drawings and make it compliant, or remove them. With regards to, I do not think the applicant has provided lumen plan. That needs to be provided. I also think, when I was looking at the Google Street View, I saw some tire racks that are placed
Yeah, they're
behind the
gone.
fence.
Yeah.
Oh, they're gone now?
Yeah, that's one of the photographs shows the tires removed, and the cover letter said the tires were removed.
There was a question I had, and that was whether the applicant is proposing to increase the parking from 5 to 10. It wasn't quite clear, because the statement says that the proposes to increase the approved number of parking spaces from 5 to 10, but then needs to say it's modifying the existing condition by providing 6 spaces behind the fence for vehicle repair and 4 in front, so which is still not adding
Yeah.
up, so that needs to be clarified. Again, I also saw vehicles parked on the sidewalk when I was on site visits, and I do also question, therefore, will 10 be adequate? Do you need more? And if you do, and you can find the place, provide it on site rather than parking
Yeah.
on the sidewalk. And we also need to make sure we have an operational plan which ensures that vehicles will not be parked on the sidewalk. I had another question with regards to the landscaping. That is, the applicant is proposing an opaque fence to screen the cars that are going to be parked for repair. And behind those, planter boxes are going to be provided. It's not going to be visible. I mean, that's what's in the plan.
Yeah, no, that's what I mean. The planter
Right.
boxes make no sense.
Makes no sense. Either you move the That's what
Right.
you're referring to?
Yeah.
Okay, that's
Yeah, it was like,
I agree
that's
with you.
nice, planter boxes inside of a cage,
with you.
opaque cage,
Yeah.
which is packed with cars. I
Yeah.
mean, the cars will
They will
crush
die.
the planter boxes, never mind die, they will
Yeah.
just be crushed.
Yeah.
I don't know why anyone would ever consider doing that, if they just don't have any room at all in there. And if our interest is to keep cars off the sidewalk, you want, and to make the place not, let's say, not too disagreeable looking. The idea of having the cars behind an enclosure, I think, is a good thing. But I don't think that they've worked out their planning, and this whole subject of cars on sidewalks, I just don't know what to do other than our compliance officer driving around a lot, and then I think it's the police, you know, it's Department of Transportation or the police who are the ones who control that, right?
With regards to the buffering, the buildings located to the right of it, they are raised above ground. There's a big grade difference from those buildings that are located from the parking lot. So there is already quite a bit of a
Wall and a
wall,
fence on top
wall
of
and
the
a
wall.
fence. So what one could ask for, I don't know if those fences were built by the residents or it is part of this subject site. If it is, then we should ask for those fences to be improved and I think that, and make sure that no signs are posted on those. So I think that would definitely improve the appearance of the site and also address the concern of the buffering that you were referring.
Right, okay.
It looks like the fences might have been added by the residents simply because they don't match up.
Oh,
You know, some of them are actually like chain link, some of them are PVC, and there's like a gap, so.
And the rest is wood, actually, further north. It's wood, slates.
so it's a haphazard fence situation.
Yeah.
At least this owner should have a continuity of the fences, so in the neighborhood, it is making more of an effort to be respectful of the residential character. Right, okay.
I have a different concern actually on the fence. I'm looking at pictures submitted on December 7th. And if you look at the first photo, which shows the fence to the west, I see cracking in the fence. And the same, it's like a V crack.
In the
Oh, that's
wall.
the wall,
Yeah.
the brick wall, you mean?
Yes, in the
Yeah.
brick, yeah, I presume that this is kind of a fence too.
Yeah,
It could be a retaining wall and could be a
right,
fence
but
in the
just
meantime.
for clarity, it's that gray painted brick wall,
Yes,
right?
yes.
Okay.
The V-shaped crack. And in the meantime, I see a light pool, and it seems that this light pool is tied to that brick wall.
Oh,
And if you look at the picture further down on page 4, actually you can see two types of fencing, the wood slates and the PVC, and you can see the gray painted brick wall, and you can see signs up there. And I get the impression that the surface grades at the property to the west of the subject property are higher than the grades at the subject property. So this kind of fence, which is cracked, I believe it's acting as a fence and a retaining wall as well. So if this is, and I see some signs blocking the slating, NYS inspection sign, auto repair, R&B, these signs are blocking the slating, and this gonna significantly increase the wind force. So my concern is this: if the wind hits, and we all know that there is a hurricane coming in probably a matter of hours, if a wind hits and these fences transmit forces to that retaining wall, the brick retaining wall, in addition to the earth pressure that's already existing there, and this wall is cracked, I'm not sure about the stability of this fence. So I would recommend that if they didn't have an engineer check the conditions, I would recommend that they have an engineer inspect this wall as soon as possible and make sure that they have safe conditions over there.
okay.
Yeah, we also need to make sure this wall is part of this property and not the.
So the wall is shown on the drawings way back when, from one of the original approvals, there was a wall. So, and it's shown on their property. So, and in fact, it's referred to in old resolutions that you will build a wall. And then in the 90s, they requested relief from building the wall, but it seems like they built it anyway. And probably needed to because they had to hold back adjacent property. So yes, so the wall needs to be inspected, and if determined to be unstable, needs to be repaired, replaced, whatever, right?
And I think, going back to Commissioner Shetta's point, I mean, whatever happens, I think any additional structural load, or any load, not structural, any load of any sort, including signs, should not be allowed to be added to the structure, which can further compromise
Right.
the structural integrity of the
It
wall.
could,
And it's not worth
if
taking
it
that
is
risk.
designed to withstand these kind of loads.
I think my concern is that it's a visual clutter, and it does take away from the residential nature of it, and so that also should be.
I think
Yes,
it's probably
this is-
excessive
And it
signage
is
at
an
the
excessive-
moment.
Yes,
It's
it looks
way
like way
over.
too much sign.
Yeah.
Yes.
Okay. Great, thank you all.
Item number 7, 30909BZ, 2173 65th Street, Brooklyn.
Okay, we have proof of service of initial application and proof of notice of hearing to officials. Community Board recommends approval conditioned on no commercial or community facility use at the site. The plans show residential only, so I have no risk of that, I don't think, unless, of course, they operated illegally or something else. I don't have any objection to the proposed minor height increase, since the adjacent building that was, I guess, subsequently built since, is much taller than the new building, the new proposed building. And the unit count, floor area, and lot coverage are all the same as what was originally proposed.
However, the basement studios are now ground floor, one bedroom, so they at least should give us some kind of a letter that discusses whether or not that impacts the value of the project.
Okay. Great, okay.
Any other comments?
Appeals calendar, item number 8, 2017, 193A through 199A, 9, 10, 11, 12, 14, 15, and 17, Tupelo Court, Staten Island, GCL 36.
Okay, so some of this, sorry, okay. So in response to community concerns, we submitted a copy of the study that their own consultant, Princeton Hydro, prepared. We submitted that study to DEC in mid-August. We've gotten no comments so far on the study. I'm hoping that we could have a phone call to the person at Eve. You left a phone message?
They haven't called us.
Yeah, okay, so in other words, just keep asking, but we got no comments, and normally they take 30 days to review, and so. DEC did, however, confirm that the permit is valid until June of 2020. BSA plans were coordinated into one set as requested, but I still don't find the builder's pavement plan, which is what I asked about the last time. So they had two old builder's pavement plans dating back a really long time ago. And I don't see an update to that matches what they submitted to us on this recent BSA set, and talked about that at the last hearing. I said, at the last hearing I had, I said, we have a drawing from September 11, 2017, which is BSA 1 through 3, an internal roadway sheet of June 27, 2018, and no builder's pavement plan that I can find that looks like either of these. That was my comment. So they put together revised BSA 1 through 3, clear, but the builder's pavement plan has to look like the BSA set, right? And if it exists, and I'm just not finding it because this has been going on for a long time and the submissions, or just give it to us, submit it to us. Also, what else? Right, I think that was it. And so I'm just hoping we hear from DEC something about their submission. Any other comments on this?
I still don't see an argument with regard to the hardship that is required in a GCL 36 waiver. And yeah, I'm not going to go through this over and over again every time one of these comes up, but you can't deny, it cannot be denied that the issues that these have come up, is particularly in Staten Island, the issues that these waivers have caused, particularly in Staten Island. Again, pursuant to the case law and how the Appellate Division and the Court of Appeals have ruled in the past, these type of projects, I don't believe these type of projects are what this waiver was intended for.
I think we might have asked them at one point about hardship, but I can't.
We have.
We did, and I don't remember.
And I think last time from my notes, I said hardship is required in GCL, and it was stated that this is an exception. That this was
no,
because the
speak
site has been-
louder.
That, from my notes, what I have is while I don't know who stated it, but it said hardship is required on GCL. This is an exception. This site has been reviewed by all critical agencies, and with that, we had closed it at the last year.
Oh, so those are two
So-
separate subjects, right?
There is
One
no-
is, can you establish hardship under the GCL requirements, which has a criteria for hardship? And then the other question, I'm not really sure how they even link together. And so that it goes through other reviews is really another thing that's not related to hardship. I mean, I think the reason we bring up whether it's been reviewed by other agencies, like city planning, et cetera, is where we say we're not in a position to review these applications because there's so much complexity. And in this case, the subject of wetlands and so on was reviewed extensively. That was the issue. So to ask us to review about wetlands, my position was there's no reason to review the wetlands again, because not only did DEC and DEP look at those issues, and proof of them looking carefully at the issues was that they created this restrictive declaration with a conservation easement where they delineate, and this last submission is very clear on where the delineated protected wetland zone is. So in its analysis, DEC obviously was looking in some way at the watershed, though we don't know what they looked at. But the idea that you create a permanent conservation easement, from my perspective, is sort of a gift to the community, because it's forever wild, right? So, but we don't have the expertise at all to look at those kinds of subjects, but in this case, DEC did look at those subjects.
And in my opinion, that resolves some of the issues, but there are others that, for example, again, if in a mapping action, there's a contract that holds the developer liable for moving forward. We don't have any enforcement authority. This isn't this person who, this lot up the block who doesn't have access, is not fronting on anything. This isn't that applicant. And that's where that application, this is why the GCL waiver, in my opinion, and according to the case laws that I reviewed, that is what a waiver's for that, one or two houses that don't have frontage. Not for a development where obviously a mapping action is much more appropriate because it addresses all these issues and holds the developer liable moving forward. We don't have any of that ability.
This case was before us back in 2013, right?
Yes.
As a GCL 35.
As a 35, it was a
because
totally
at that-
different kind of a question, 35, though. 35 is just, can you build in the bed of a map street? And then the simple question is, does DOT kill? Yeah, does DOT still care? The answer, no, done. We never really look at any, sometimes on a GCL 35, we'll notice it doesn't comply with zoning or something like that, but we don't get into any further, because it's really just to protect DOT's interest in eventually, yeah, its street system. Or DEP's interest, sometimes we also
With
find
their
that.
sewers
With
or
their sewer system. We
water
have one like that, where it's sort of stymied because DEP wants to maintain their easement area. Yeah.
So do we have a plan if we don't hear back from DEC by tomorrow? What are we gonna do?
Defer to another.
Well, I'm not sure. We'll talk about it. I mean, my feeling about it is DEC is the purveyor of its wetlands and stormwater and so on treatment. We can certainly make approval contingent on compliance with DEC review, right? But it's not like we are going to, I don't know. I don't know that there's, I don't actually know what DEC's instruction would be. We could condition it, and if DEC says, uh-oh, it shouldn't have been laid out like this, then they have to come back to us because it's going to have to be laid out in a new way. I mean, that's the reality, because, right, the approval would be for this road with this roundabout. If DEC says, terrible, it needs to be laid out in a completely different way, then we didn't approve that, so.
Well, it will have to go to city planning because they need to
Well, so-
have it revised before it even comes
Right,
to us.
so-
there are many layers of review that's going to be involved in this.
Right, but
So
but
there's that.
as to our, yeah, but the point is that DEC, and I think that's what distinguishes this case from most of the other cases we've seen, is DEC and DEP and city planning reviewed this case very thoroughly as to the flooding situation, right? So because you're because you're dealing with wetlands and adjacent areas to wetlands, right? We didn't look at it, we don't understand it, but we know that they reviewed it carefully because of the restrictive declaration that was involved. I think that's the main difference. And the reason we're reaching out to them again is in appreciation of what the community is concerned about. And the community did a study, which we're not in a position to review in-house, right? So we give the study to DEC, and if DEC finds the study persuasive or calls into question their own determination, that's DEC's work, right?
Right, but again, there's two parts here. One, they didn't make their prima facie showing. To satisfy the statute, they have to show a hardship. They never did that. So
I think your colleagues are acknowledging that there are two separate
Right.
inquiries, that
Yeah,
there's the
yeah.
hardship and then there's the case that the community is concerned about wetlands and that this project has been reviewed for compliance with wetlands.
But, and it's not, I find it that to put this onus on the community, but that they went above and beyond to show that, to do this study, this is something that would have been, I believe the review would have been different. This process would have been very different if it went to a mapping action than through this very action. To grant on a condition, again, I don't, and just have them come back if they don't comply, I don't think is really a service to the community especially after doing this very thorough study and providing that to DEC.
Could I just ask a question here? Can you clarify your agenda as regards GCL 36s for the audience so that people know in the future whether or not they can actually partake of a GCL 36? Because it sounds to me like you're trying to move the board in a direction that we no longer consider GCL 36s. So if that's the case, I think you need to basically make a statement as to that so that the public is notified and can act based on what they know, as opposed to coming in for a certain number of hearings and then getting stalled at the last step.
Well, I'm relatively new to the board. I think I've made my position very clear that GCL 36s should be limited to those one or two homes that have that aren't fronting, and it would be an unnecessary hardship for them to go through the whole mapping action. And that's a complete discretionary review if we see such a small type of project. But on these larger developments where there is no argument for hardship, that they're creating lots that aren't fronting through their own through their own development, that's not appropriate. And I think that the case law supports that. And if anyone who does any research into it would see that when these have been denied by the board for the reasons of not showing hardship, when 6 lots have been denied because there was an alternate way to front onto a street, and the courts have found that mapping is a far more appropriate, that's been upheld. So,
Okay, so you know what, maybe we need more clarity from that. So on another case we have, where it's a very simple little case, where it's one house or 2 houses or something, we asked the applicant, please brief the hardship analysis and using case law that exists, right? So there's a lot of case law, I don't know about a lot, but there's several cases that we found where the courts have looked at when a municipality refused to issue a GCL waiver, and the court directed the municipality to do so because there was clearly a hardship in that case. It was one little homeowner or 2 or 4 or whatever. But what's not clear is what's the magic number, right? And so I personally am looking at it as when it's a few houses as opposed to many, and what's many versus a few, but still, when it's a few houses, I kind of understand the idea of going through an entire ULURP action and all of that stuff as being onerous, and perhaps in this case, because, DOB was granting these as of right at the time that
Yeah, they
this.
would have just
yeah.
needed 35, and they would have allowed everything else. The only thing it changed recently, and that's why it's before us for 36.
Yeah, no, but what I want to say is that DOB was, if they weren't, never mind whether it went to city planning or it didn't go to city planning, up until fairly recently, DOB was not even acknowledging there's such a thing as a GCL waiver. They were just allowing these things to be built as of right. So some of these applications got caught in this sort of in the transition between DOB realizing actually has no authority to do this, and then sending them to us. So this case that spent so much time at city planning with this whole water wetland area could easily have been also going through a ULURP action on a demapping simultaneously, right? And because it did, and it went through a huge community review. That was the other thing that's important to know, and that's why the community keeps coming here, because they were made so aware of it way back then, right? So, but I still think it's because this is a little cluster of houses as opposed to a big development where I don't know what the magic number is.
I think, though, for the board's sake, as well as the public, we need to articulate that
Yes.
threshold.
Yes.
Because otherwise, there's no clarity,
Yes.
and there's
Yeah,
no
I agree with
ability
you.
for them to have expectations as to where they need to go and how long it's going to take for them to get their appropriate
Yeah,
approval.
I agree with you. It should be clarified.
I think they can find some, I'm sorry, I think they could find some guidance, particularly in the matter of Brock Properties, where it was upheld
Brock
that.
Properties?
Brock Properties, where it was upheld that it was not arbitrary and capricious for the board to consider whether or not the owner or the developer had an adjoining property that had frontage. And what that really boils down to is, if you're creating the situation where you need a GCL 36, then perhaps you don't have a hardship. If you're creating the hardship that you're not fronting, then perhaps you don't have a hardship.
I don't think you should be asking the applicant community to look at case law that I'm not even sure, first of all, I'm not a lawyer, but I'm not sure is actually appropriate for every case that comes before us. I think as a city agency, we have to articulate a standard and we have to stick by that standard, plain and simple. And the standard cannot be, hey, you out there, go read what you can, see if it applies to you, and then make a decision yourselves, a subjective decision as to whether or not it applies to you, and then come take your chances here when we may have a totally different opinion. We have to articulate a standard, and that standard has to be a very concrete threshold number. Under 10, come here. Over 10, no. Over 12,000 square feet, no. Whatever it is we decide, we owe it to the community, because this is a very substantial shift in the BSA policy.
And while I agree, that I don't think it's as simple as a number, because there are a lot of other issues that can be things that we're not prepared to review. If it were to be a number, then the numbers that are more relevant, more obvious in the case law, I believe the number was 4. That's when it's been returned back to the BSA for like when it was 4 properties. But so if the number is 4, and then we can look into to see if there's any other substantial issues that we'd at that point have to say, no, we're not, this isn't available to you because we don't have the expertise or the enforcement ability or the expertise or the tools to do an appropriate review, that then a mapping action is more appropriate to them. That might be the best way to handle it, or at least my position on it.
A city agency should never implement a policy that's nebulous, because that's just going to cause problems over and over as we go on.
I think
it's not good policy for a city agency.
But just to say, in hearing your comments, Commissioner Strubita, about this application, you will acknowledge that number of structures does have something to do with
Absolutely.
right? So
It's not-
I think we can all agree that there are some
Yes.
bases on which they're all fact specific,
Right.
but there are maybe some directions we can provide to the general public, to our applicant pool, that will give them more guidance, as Commissioner Otley Brown is suggesting.
I agree.
That would make our relationship in terms of these cases in the review
Right.
more reasonable, more predictable, and more certain in terms
Yes.
of time. So I
Right.
think we're
Right.
kind of all.
Yeah, I think we need to move on, but
Yeah.
I do agree that there is probably a number where we can look at that in our minds satisfies that hardship criteria, because that's what we're talking about, where the board has inconsistently asked for, because we do see it in some of the old cases, inconsistently asked for the hardship finding to be articulated in the resolution, and it needs to, from now on, move forward and always ask that that be established. And we've seen applicants in the last few months struggling with how to make a hardship finding, but the hardship finding can't be, it takes too long, right?
Right.
So that's actually not what a hardship finding is. The hardship is something more like what we've seen expressed in the case law, which is that it would be unreasonable to ask, the most obvious ones, an individual homeowner to go through a mapping action, in particular where you've got 5 houses down the street, but they don't qualify for that GCL
Exception, because they don't have certificates of occupancy,
Right.
for instance.
Right.
For
And
instance,
that, I
that
think-
would, those kinds of things, those are very obvious. So you point to the obvious argument, and then in that case, like on a variance case, we do ask the lawyers to make the argument, what's the hardship, right? So I don't think it's inappropriate for us to ask
Ask the
them to
question.
make their case, and then we review it based on that. And in another case we had, they tried to make the case that it's a hardship because look what would happen if we didn't go for the frontage waiver, but that's not the same thing as what would happen if you went for a mapping action. So the question about the hardship is not what are your other alternatives without a GCL waiver, it's why can't you have a mapping action?
Isn't it both?
Well, maybe.
Because the
yeah,
statute isn't
maybe not.
specific as to what the hardship
Right,
is.
I didn't see that there was a specific reference
there
that it
isn't.
has to be a mapping action. And so, I know you don't want to belabor the point here, and this probably isn't the place to do it, but I think that we are a board of 5, and all of us need to have input in this, and part of it starts with a briefing of the law by council to all of us, so that we can all weigh in on what a new policy should look like, because I know that we are not all in agreement as to what a new policy should look like, and no one person here can exert control over the others.
Right.
So therefore, this should be something that is looked at.
Good recommendation. Okay, thank you.
Thank you.
Okay.
Continued hearings, item number 9, 215-15A, 144-14, 181st Street, Queens.
Okay, they requested an adjournment. They actually have drainage plan issues, and they need to work out that with DEP. So that's actually relevant to what we were just talking about. It's a GCL 35 waiver, and DEP is adamant that they need to work out something with respect to their sewer easement.
Item number 10, 2017-5A through 2017-7A. This is 620A, B.C. Sharretts Road, Staten Island.
Okay.
It's a GCL 36, commercial use. Warehouse, sorry.
Yeah, warehouse, that's commercial. Sidewalks along the frontage were provided as we requested. I think the other issue that was resolved was the question of whether cross easements are needed for each of the 3 buildings, but it appears that they all sit on one tax lot, so arguably that's all in the same ownership. The buildings are labeled to be fully sprinklered, which was a fire department requirement. DEP required a storm and sanitary disposal plan, which was submitted to us on August 15th, but I don't see DEP sign off on that.
No, they haven't responded yet.
Okay, so because we still need to hear from DEP, there's time to add notes to the drawings that depending on how DEP comes out on this, this was a DEP comment at their last submission in March. It says, "It is anticipated that the proposed sanitary and storm sewers and water mains that will likely be built in the fire access road will be maintained by the private owner, not by New York City." So I would like a note to that effect. So assuming for the moment that sanitary storm sewers and water mains are located in the fire access road, they shall be maintained by owner, not City of New York, and that should be a note on the drawings. And that would be a condition also. Anybody else on that? No.
Item number 11, 2016-4330 and 4331A, 1619 Tuttle Street, Staten Island. Item number 12, 2017-30A, 16 Garage Tuttle Street, Staten Island. Item number 13, 2017-226A, 18 Tuttle Street, Staten Island.
Okay. So I just want to correct a statement in the cover letter on the last submission. This case was adjourned for June 26th and was last heard on March 20th, because it refers to the last hearing, but it didn't occur. So at long last, the project has been redesigned so that the house on the through lot has its entrance on Home Place where it should be from an urban planning and neighborhood character perspective. The architect should make sure that the vegetation marked, quote, "voluntary screening" located between the private road and the adjacent zoning lot should not in fact be what's, quote, "required screening" under section 26-35, in which case it needs to be 8 feet wide, as described in the zoning resolution, but I think they actually mean 8 feet deep. And I see in the cover letter that the sidewalk between the zoning lot line is viewed as exempting the site from screening. I don't see where in the text that comes from, so I'm not sure that they're exempt from screening. There is an additional information 1 form that the applicant submitted to DOB for curb cuts and to clarify the screening and private road requirements. And I read that additional information form as requesting zoning waivers from DOB for some of this criteria. DOB doesn't have authority to waive these requirements, so I'm hoping that they're just asking for clarification on the text.
And we haven't seen a
opposed to-
response to that.
Yeah, so we haven't heard anything, but I read it like a request to be absolved of the requirements, so I didn't really get that. There's a homeowners association agreement that we received in February 21st. We need to clarify for this property whether a utility company or other entity is actually responsible for dry wells, sewer pipes, wires, conduits, public utility lines, and if not, they need to take that out as a proviso. The way it's written is it says, the association is responsible for those things unless it's taken care of by the utility company. That leads the property owner to have no idea who's in charge of it. So either the utility company is in charge or it isn't not. They can always amend the HOA in the future if they need to say, now the city's taking care of everything, but as of today, the property owner is taking care of all that. They need to clarify also the metes and bounds of the association property and which properties are entitled to the access easements. We actually asked for the Schedule A and B at the last hearing and didn't get it, so that's the metes and bounds, right? And more than just a metes and bounds description, there should be a map, so everybody knows exactly what is association property. There also needs to be some sort of formal document that ties the current owner, which is the Zion Lutheran, into the rights and obligations of the association. So it's some way of, because it's Zion Lutheran that's making this deal, and then they're going to be transferring it over to this purchaser. So there needs to be something to show that whatever the agreement is today carries forward, runs the land, basically.
You want recordation of this, of that restrict?
Yeah, of course. So the HOA needs to be recorded. There also needs to be a restrictive declaration, which we still don't have, on maintenance and parking restrictions. That's a separate document from the HOA to clarify to everybody who's responsible for what. And then we discussed this earlier, that the builder's pavement plan should be a condition prior to permit as opposed to prior to C of O. Anybody else on this one?
I'm sorry, BBB approval should be a
Yeah.
condition? Got it.
Again, I didn't see a hardship argument in their statement. I'd like them to make one.
Okay. So in this case, this is much more similar to the case law that we see.
Right.
There's basically two houses that are relying on that frontage, which was one of the reasons we turned, not actually a reason, there was an urbanism reason for wanting that home place house turned around. But there's only two houses relying on Tuttle for access. The home place house can go both ways. It's basically a through lot, or it is a through lot.
I'm just saying for, as
For
a
consistency.
consistency
Yes.
and.
Noted for the record, thank you.
Okay.
Zoning calendar, decision items, item number 14, 2017-209BZ, 1622 East 29th Street, Brooklyn.
Okay, hold on one second. Okay, sorry. Demolition drawings were corrected to show 50% of the perimeter walls on the perimeter and all joists to remain. We had a comment at the last two hearings, I think, that the floor area in the attic isn't explained. I still don't see the clarification on the floor area in the attic. It just shows the attic, doesn't tell you, doesn't show calculations, and then the amount of floor area brings the whole building slightly over 1 FAR. So that's why we asked for them to clarify, but they never did. And I don't know why, because we keep asking for it and we're not getting it. That was like, yeah. Okay.
Good. Move on? Continued hearing items, item number 15, 7715BZ, 244-3680 Fifth Avenue, Queens.
They requested an adjournment.
Item number 16, 87-15BZ, 182 Minna Street, Brooklyn.
Okay, they requested an adjournment for 4 months. This adjournment is the last adjournment on this item. This item has been in hearings for over a year, with the last and only hearing over a year ago. So our council will send a certified letter, return receipt requested, to owner and council, advising them that this is the last adjournment, after which the application will be dismissed. Okay?
If I understand it, they're seeking the adjournment because they're trying to develop this site as of right.
Yes.
Yes, or find another site or something like that, and they just want to hold their options open, but we can't keep things on the calendar while they figure stuff out. If they want to withdraw and resubmit in the future, that's their business, but frankly, it's really
Agreed.
bad for our statistics when we leave things on the calendar like this. It
Just noting that
hurts
we
us.
have to report our statistics
Yes.
once a year annually, and then
Right.
the first quarter of the year.
Yes, so it's required now by the recent laws.
Local laws that were passed last year.
Yes, that were passed last year, that we have on the public record, how long it takes us to process an application, and these kinds of applications that sit around for the benefit of the applicant with no movement hurt our numbers, and then we get calls.
But I don't think it's a number. I think we're doing it because it's failure to prosecute, and it'd be,
No.
it'd be bad if
No, it's failure
applicants-
to prosecute,
Right.
it's been over a year, but
Right.
I'm just saying, the reason that back in the day, the board would take things off calendar to allow the applicant to figure life out, and things were off calendar for 4 years, things like that,
Mm-hmm.
right?
It also just hurts the applicant pool by clogging up the calendar.
There's,
Right.
there's that,
Exactly.
and there's,
Taking up space, yes.
right.
Yes, because, we had a hearing scheduled for today, and someone else.
Someone else could
come
have taken
in.
the spot, and
Right.
yeah,
Right.
weren't able to.
Right, and that's been the third adjournment. So, okay.
Item number 17, 2016-4171BZ, 823 Kent Avenue, Brooklyn.
Okay, where am I? Fire department provided a letter stating that there is inadequate access for firefighters to the back building using this 8-foot wide access drive. And we also still had an issue with with an open Phase 2 that needed to be done. My question, which I'd really like fire department to discuss with us tomorrow, is I'm trying to understand sort of the science behind the decision that this 8-foot wide opening is inadequate. So, for example, if it were a 12-foot wide opening, would it have been adequate? What are the firefighting techniques that the fire department operations looked at when they said this is a bad thing? One of the reasons for this is that this site used to have a front building that burned down, right? And that front building, as far as I know, had no access through. It had no side. It was built full to the lot line.
It was a full lot line
Yeah.
building.
So, and it's not to say, and I know that, and historically, New York had lots of these things that were called front buildings and back buildings, and I understand that the building code eventually disallowed those, probably for firefighting and health and safety reasons and so on. But for one, this is an extremely deep lot, and the idea that there's this one little house all the way at the back, and then that's sort of the end of the story, is unfortunate, I think. And it seems to me that there's probably a design solution with a creative architect and understanding the firefighting science mixed, where there could be a project here. But because I don't understand what the issues are, and when we look at these GCL waivers, for instance, sometimes the roads are pretty narrow. So at what point is it okay? And is the firefighting equipment always a truck that has to drive down there to the back house, or is it other kinds of equipment that drives down to the back house, et cetera? And I actually have a personal sort of interest in the issue of affordable housing in this subject, because I'm really interested in the possibility that back houses where there's adequate egress from the, access from the front could be developed in neighborhoods, and where you could get really sort of low rent units inexpensively built in the back, and working with fire department to figure out how to do that. It's actually this theme of mine, and this case brings to light issues that I hadn't considered. We went on a site visit recently in the Bronx. I forget what street that was. I took pictures of it. What? Walton? Maybe. Bowler.
Bowler Ave.
Bowler. So right, that side street had these beautiful little front houses where they had shared driveways next to each other, and the shared driveway width maybe 12 feet. And behind that, beautiful little houses with porches and a little turnaround and all that. Maybe it wasn't quite 30 feet, but close. And I looked at that as an incredible typology for, potential affordable housing development. And so this is, thank you, yeah, exactly that. So that was Bowler? So anyway, this is a subject that is of broader interest to me than only this application, but I do feel sort of sympathy for this property owner and the idea that they can't rebuild what had been there, and at the same time, concern for the fire department never wanting to put firefighters at risk or the public at risk if the fire department thinks it's a problem.
Yeah, I think I want to add to what you're saying is not only this allows for opportunity to create affordable housing, but also create housing, period, because there is a tremendous need for housing. And when such kind of properties do come up, I hope sincerely that all city agencies are working together to find ways to afford these housing possibilities, which can make it possible for many of us who are living in tight-end conditions to live in a better condition.
Right.
And in such neighborhoods. And this is where you see these kind of unique kind of site, because these sites were not necessarily residential, they were kind of in transition zones. And, and the solution that was proposed on this one, both the buildings were going to be sprinklered, both the buildings were going to be much more technically improved than the conditions that you saw in Bowler. So I'm also curious as to what are the technical defaults that were there that didn't pass the muster.
Right, yeah. So we really, it's to understand the science and to try to work with fire department to come to a solution that might have a broader application that we could get involved in, for example, because maybe, building new back buildings or something like that isn't something that's permitted under the zoning resolution, under the building code, under anything. So maybe that's something where the BSA could participate if we could find out a great, safe solution with respect to all the codes that implicates, right?
Were you standing in the green? That's bold.
Anyway.
Good? Mm-hmm. Item number 18, 2016-4472BZ, 24501-24513 Jamaica Avenue, Queens. It's a PCE for variance.
So just going to kind of go over the history of this site a little bit. So just as to get us refocused on what the issue is here, because this is about a variance for a PCE that was established in 1994 by the BSA as PCE special permit under calendar number 12-94BZ. And that allowed a PC to operate in a C2-2 zoning district for a term of 10 years, which ended in July 29, 2004. And the site was rezoned subsequently, such that that special permit for a PCE is no longer available. The applicant represents that the PCE has operated continuously since the expiration of the term and has been in compliance with the board's conditions and safeguards since then. But in furtherance of our understanding of this, we should see proof of that. So we need proof of continuous use and proof that the use has been in compliance with the board's conditions and safeguards. And, you know, and to that point, when we see extensions, applications for extensions on these use, sometimes somebody, PCE doesn't come back to us for several years, sometimes 10 years, more than 10 years. And what we do is exactly that. We ask for continuity of use proof, and we ask that if they're not in compliance with the terms of the grant, that they put the property into compliance with the terms of the grant. And then after they've shown us that they've done that, then we grant the extension. So unlike an illegally established use, this PCE was established pursuant to a special permit granted by the board. At that point, the applicant could have returned to the board for an extension of term. The board does frequently, as I said, grant extensions of term upon findings that the circumstances warranting the original grant still obtain, that each of the original findings have still been satisfied, and that the applicant has complied with the conditions and safeguards theretofore described by the board during the prior term. Because extensions of term are discretionary, however, the board can decide not to grant them, is not obligated to grant the extension. What is not clear from the zoning resolution is that upon a rezoning, whether the zoning resolution intended to circumscribe the board's authority to grant an extension of term to a PCE use that had been lawfully established. So it actually, as we read the text of the zoning resolution, it's not 100% clear to us, not even 50% clear to us, whether the zoning resolution intended in the case of a rezoning to essentially gut the opportunity to occupy to have a PCE in that location, and or to render it impossible to continue with an extension. So it's almost like, could the zoning resolution have intended to put a PCE out of business? And as a counterpoint to that, we do see that there are some non-conforming uses that the zoning resolution did intend to amortize out of business, right? Illegal advertising signs, for example, special adult uses, things like that. So, and those are viewed as being detrimental non-conforming uses, essentially nuisances that should be eliminated. But the PCEs are not viewed that way, and in fact have become contributors to our society as opposed to detriments.
So here's a question, because I'm just thinking about it as you're talking. If not for the zoning change, in a traditional case, when an extension of term is ripe, so to speak, and the applicant does not come in, so they're kind of without a term for several years, and they do finally come to us and we grant, don't we grant back to the date of the expiration? Which confers like legal status from that date.
Yes.
So if we were to do that in this case and actually
Oh, that's
grant
interesting.
retroactive to that expiration date, then they never had a period of illegality, and then they really kind of don't need a variance, because wouldn't they just be still legal? Just taking your thoughts a little step further to wonder.
Okay, so the thing is,
be
though, that
consistent.
this ran out in 2014,
Right.
which would only give them a couple of years left on this, and then,
We have,
But they would have
Yeah.
to file
Cases
for
we
that,
have done.
right?
Yeah, yeah.
I'm sorry,
Go ahead,
Mr.
go ahead.
I just want to clarify as a matter of procedure and for our rules, special permits with a statutory term can only come back within 2 years after expiring, otherwise they're required to file a new special permit.
But we often have these special permits that come to us where, I mean, it
Like
was
14
Steele
years,
Roberts,
12
10,
years,
15
yeah.
years, right? Almost all of those came back with no,
Not per our rules.
well, they did come back for,
Well, if,
so,
We can waive our
So,
rules on a particular
right.
case, but they'd have to do the appropriate filing, I believe.
right,
just
but
wanted
so,
to just
okay,
reiterate what's in
and,
our-
but so what we're looking at is also, what is the zoning resolution telling us to do? Not just what our rules are, but what's the zoning, and all of this is because I'm looking at this more as a belt and suspenders. I'm saying, they're here for a variance, right? And we directed them
To file the variance.
file a variance because we weren't sure that we had the authority under the text to extend
the
the
term.
PCE when the zoning has changed to the C1 district, right? But what we're doing is we're looking at whether we can view, this is the reason this is coming up, whether we can view the existing PCE as effectively an existing non-conforming condition so that we can say, you've got a history of use on the site, like a gas station that didn't come back for review for 25 years, and the history of use on the site would mean that turning it into a conforming residential use, because they're always in low-rise R districts, right? Turning it into a conforming residential use would have made it onerous, right? So this is in the interest of looking at that it legitimately could have extended its permit in 2004 when it expired, which would have been 2014, it would have come for a renewal, and the rezoning, I believe, was after 2014, so it could have extended it again. And so the idea that we've got an existing, effectively non-conforming continuous use that's never been broken would then allow us to look at this as a built space, and as opposed to what we had discussed at the last hearing was that you have to look at it as vacant space. Because I don't think the public policy interests in the zoning resolution were to put PCEs out of business by sort of fiat, effectively. One day you're in business and tomorrow you close and you didn't do anything bad. You know, and you're not one of those on the amortization list. So, and that way we could look at the existing use as unique physical condition as in terms of the history of use as a basis for the variance, because we've been struggling with what is the A finding here.
Right, in which case then we would, I hate to tell the applicant this, revive the first financial report, which is based on the cost to convert to an as-of-right use.
Probably is easier.
Well, they've already done it, so, you know,
Yeah.
so basically.
She did a lot of work that we directed her to do.
Right,
but,
exactly, thank you
Which we
very much.
very much appreciate,
Yes.
Yeah, we totally appreciate it.
And we just want to say that, you know, we're trying to pursue the truth so that in this case, they might be able to secure a grant. So it
Yes.
is to their advantage to do
Right.
all that extra work.
And I wanted to add that we have a couple of other cases that where I don't particularly like how the board resolved them, but what they did with those variance cases is they treated the variance exactly like a special permit with all the same approach. So it's a 10-year grant, and and it needs to retain the same ownership, or they have to come back to the board. And that way, you wouldn't get sort of an abuse of what this was. So if a future owner comes in and they're gutting the space, then you don't have the same kind of an argument as in this case, right?
And the ownership didn't change.
No, ownership didn't change, but in other words, going forward, you treat it like you do the PCEs, where ownership has to come back if it changes.
So you want those conditions attached?
Yes,
You
so
would.
it would be treated the
And will it
same.
then be farmed out to the IG to do the background check like you do? Because
Yes.
that's really what the special permit's purpose is to
Right.
ensure legal, fitness uses and not
Right.
illegal
Adult
kinds of
physical
adult physical uses.
Yeah.
Just to clarify, for the board, there was some discussion with Mr. Costanza about the time to file an extension of term. Extensions of term for special permits that have a statutory term, like the PCE that have 10 years, our rules require you to come back within 2 years. If the grant was given a term by your discretion, so it wasn't required by the statute, they have up to 10 years to come back. Or about up to 4 years after.
No, at any time, they can file an amendment to the condition of the term, which was a.
At any time, they can-
condition only, and not a statutory.
As
requirement.
opposed to a requirement, I see.
So there's a
Okay.
difference between statutorily required terms
Right.
and those that are discretionary.
Okay, thank you.
Item number, maybe go on?
Oh,
Yes.
wait, can I just
Yeah.
say, since they're going to go back to that first report, then the other comments I had made about the first report should stand, which is don't use the existing leases to forecast future leases. make sure it's actually following the rules of a typical appraisal that uses comp-based assumptions
Right.
straight through.
Okay, and I just wanted to add, the architect is seeking a waiver on ADA compliance, so, because there needs to be an elevator that goes down to the lower level, since the showers are on the first floor, but the activities are in the cellar level, and unless you repeat the activities, I think you need an elevator, so. They could have a lula. I don't actually see the objection to putting in an elevator. There's inexpensive-ish one-stop elevators that can be installed, or even a stair lift that would qualify. Okay.
Move on? Item number 19, 2017-131BZ, 77 to 85 Jerry Street, Brooklyn.
Okay, so I'm still having trouble with the programmatic analysis, and I don't see the simultaneous occupancy in the prayer rooms and the sanctuary spaces described yet. The programmatic needs report states that the sanctuary space is used every day as a place of study, so I don't also understand why its proximity to it from the mikvah floor isn't equally important, and the reason for asking this is because the sanctuary space is tall, and if you put it lower, then you could set back on the third floor, or the second floor, or it's really effectively the third floor then. The statement of facts states that the mikvah will be used by up to 600 daily visitors, whereas there are approximately only two, and that it's for men, it's not a shared mikvah. So, and there are approximately only 200 male members of the congregation. So that tells me that this is to be used by outside patrons, and that's good. It's going to be a very active, like borderline as if a commercial use, right? And I don't see anything on the site that handles that kind of pedestrian traffic. I mean, this is going to be hugely active all the time, and I didn't see them creating something that gets people off the street or in any way manages that constant flow. And if there are certain particular hours when people go to the mikvah that are concentrated, then it really needs to be able to handle waiting and all of that, and I don't see that it's doing it. The statement of facts makes reference to a rabbi's office, which I don't see on the plans. It also states that the rear setback occurs at the third floor and is 35 feet deep, but in fact it occurs at the fourth floor and is 30 feet deep, so that needs to be corrected. The section through the building needs to show the mezzanine in the sanctuary. It doesn't. It's like there's no mezzanine in the sanctuary. And
You
no.
had asked for it last time.
Yes, and they also never gave us section P13, which would be the drawing P13. I believe that's where you would see the section through the mezzanine, because the section we have is through, oddly, the elevator shaft. And they need to show side elevations and indicate the exterior facade materials, and of course, they are not to be styrofoam in any of its forms.
Did you pick up on the height and setback? On
The mistake in the statement of facts?
no, in the drawings with regards to the height and required height and setback?
Oh, no, I didn't talk about that. You want to do that?
Well, the plans that has been submitted, I'm still not sure how it is meeting the required height and setback requirement of an R7A district, and the street wall requirement, and that to a large extent will also determine how the dormer calculation is being made. Now, I understand that the residential use above the sanctuary, the synagogue is not before us, but this definitely is something that we are, if it cannot be addressed here, we need to make sure DOB reviews it and ensures that it is in compliance with the zoning regulation. We are not opining on it.
Right.
From my understanding of the zoning regulation, I do not believe it meets the street wall requiremms and the setback requirements, but.
Can you explain?
So the
specifically?
requirement is in an R7A district, let me just go to mine.
23,622.
C1,
662, right? 621 and 662?
23,622. There is a table 2, that requires, in an R72 district, a minimum of 40-foot street wall height and up or to a maximum of 75-foot street wall height is required. And given that Jerry Street is a narrow street, at any time the street wall is terminated, it has to set back 15 feet. And then it rises up to the maximum height of 85 feet. In this case, the building is setting back by about 5 feet and 10 feet from the street wall above the synagogue, so which is about 40 feet. But and then it rises up to 85 feet. However, in the drawings, it is represented that the street wall height is actually up to the maximum permitted street wall height, which is 75 feet. Actually, they're building it up to 68 feet, but basically they're trying to max it out. And then the setback of 15 feet is provided, and from there, the dormer rule is being applied. And that is very critical to establish where the street wall height is being determined, because that will determine the dormer requirements.
But it's not just dormer requirements, it's also, one approach is that between the 40 feet minimum base height and the 75 feet maximum base height, you're not allowed to set back and then have fully set back and then treat the 75 feet as where you're creating your base height. That between 40 and 75 feet, you can only have outer courts and recesses.
Right.
And so that's the issue, because what's done here, and I'm a little confused about why they're doing it at all, is that they're creating this setback floor at 40-foot height and then rising straight up, and then they have their 15-foot setback. So the massing is not encouraging sort of a street wall with modulation. There's no street wall after 40 feet.
And those setbacks of 5 and 10 do not meet the requirements of outer court or recesses.
Right. So one approach is that the architect needs to clarify these things. The other is that we would have a condition that's on the drawings, clearly in very bold letters.
Especially on those pages.
On those pages, and also in our resolution, but very bold letters, because we need DOB to see it, that DOB needs to review compliance of the building at the 4th floor and above with the zoning resolution, and in particular with street wall setback and dormer regulations in 23-621 and 23-622, right? Those are right. Okay.
I had a question. Did they ever address the issue we raised about the residential and the congregation sharing the residential lobby and elevator?
No. Oh.
Remember, we raised that
I
as
thought
an
that-
issue?
yeah.
I don't remember if we got a response,
No,
but we didn't get it in
any
writing.
response. Right.
I had some questions with regards to the program and what the last submission that was made, it was not clear about the number of congregants that will be attending the study group, and whether these study groups will be individual, whether they'll be attending the study in groups or individually, and what are the hours of these, typical hours of these study groups, and if these study groups are scheduled. My reason for asking this is also the statement said that some of these study groups are going to be held in the main sanctuary and also in the women's,
Yes.
where the women are going to sit. So I would be curious to know whether the seating arrangements there are fixed or they're movable, because I'm sure to make space for these various study group sizes, you have to have the flexibility to move these furniture
Yes.
around and to create these groups.
Yes.
And that leads me to the next question, is then why can't those be used for prayer purposes?
Yes. Right. I think you asked that at the last hearing and it wasn't addressed.
Okay.
I just had an additional question, which is, I guess, probably similar to the same as your question about the mikveh, but to talk about it in terms of the programmatic needs of the congregation. Because when they're discussing why the prayer rooms have to be located as close as possible to the mikveh, they talk about how the mikveh is open to the community. And I think that the waivers that we grant should be based on the programmatic needs of the congregation and
Yes.
not the community. And we usually have had this conversation with other applicants where they want to open up a floor to the community and then ask for a waiver. And in this case, opening the mikvah up to the community and then saying that's the justification for why the prayer rooms have to be on the first floor
Right,
is an issue, because that could possibly be what's driving the waiver for the height in the rear,
right. Okay, that's fair. Yeah, yeah.
both in the number of prayer rooms and also their location.
Right, right. But so I think what it's coming down to is we see these schedules where it says, you know, every 45 minutes or something, there's a different prayer group, and they're occupying those rooms, but we don't see how many people we don't have a schedule that indicates full occupancy at any given time that would justify the need for both the sanctuary and all of those prayer spaces. It's quite normal for us to see, that's the other thing about the mikvah, it's normal for us to see prayer spaces in the cellar, and then the sanctuary on the first floor. And we have seen mikvahs, but not mikvahs designed to handle 600 patrons. So that's the other part of it. If the mikvah in servicing a broader community is driving the need for the prayer rooms to be on the next floor, that's another issue.
Right, and also to have such a large volume of them, because if you
Yes.
have 400 members, including children, how many of those members are grown men who need the mikvah?
Yeah.
That's what we need to be
Right.
basing the number of prayer rooms and the mikvah and the prayer room location on, not the fact that you could have an additional 500 people or 400 people coming from outside and also coming through
Right.
your community, which would be fine if it was as of right, but it's not. You're asking for waivers in the rear.
The paper said that there are 212 families, so that's 212 dads.
Right.
And I don't know at what stage the boys are then entitled to join in this process. So that needs to be discussed too, like what's the actual number? But it's really sounding like it's about 200 people.
Right.
In which case, that's a big mix for 200 people.
And a lot of prayer rooms for
Right.
Yes.
200 people.
And there
If
is
if each room could accommodate up to 45 people, you need 4 schedules of,
Yes.
And there is a school abutting this proposed synagogue. So there is a high volume of pedestrian activity on this street as it is.
Right, so it needs to be addressed. You can't just put 600 people on the street and not handle them in any way, so. Ready?
Just,
Yeah, okay.
one minor thing, on the submission letter, I see that it's talking about item number 2E, it's talking about a line of sight diagram on P13. I didn't see P13 in the drawings.
Oh,
So
yeah.
the plans,
Yeah, I didn't, P13 isn't there either. You said P15?
no, P1.
13, yeah, I also said.
Yeah, this is one thing. The other thing, it's minor, but looking at the plans and the identification for section AA, first of all, the plans show 2 sections, AA and BB. There is just one section, which is.
That's
AA.
on P13.
Yeah.
That's the people.
And AA, it's either mirror the identification or mirror the section itself.
It's backwards, you mean?
Yes,
Yeah.
it's mirrored. So if you look at the identification, the stairs should be to the left, the staircase should be to the left, and then the rest of the building is
Right.
to the right. It's the opposite. So it's either mirror the identification, which is more simple, or mirror the section.
You know what's funny about that is that only happens now because of CAD. Computers. Because you cannot see that you've drawn your little arrow the wrong way, because when you used to do it by hand, you put a drawing on top of a drawing, and you couldn't do it backwards. Otherwise, you're thinking in mirror, and then you're a very brilliant person. You're like Leonardo da Vinci or something.
Benefits
So-
of good old days.
That's
Exactly.
true, yeah. But fixing this in CAD, it's gonna
Right.
take like probably 2 seconds. Yeah.
Okay.
Item number 20, 2017-213BZ, 1808 Coney Island Avenue, the Brooklyn.
The Brooklyn.
Sorry,
Oh, Brooklyn, like the Bronx.
it.
Like the Bronx.
The Brooklyn, but the Bronx.
The Queens.
Okay, plans were revised to show that there is no elevator override. So I'm really interested in this subject because we often have applications, also at Landmarks, this was also a thing, with buildings that are of the same height, that claim that they need very, very tall overrides or overruns, and especially in buildings of this height, because they say that hydraulic elevators don't travel this many floors. So I actually looked online, and I was getting not quite as tall as this for hydraulic elevators that have very effectively no overrun. So I'd like to know what type of elevator this is, and is the architect sure he or she is right? I think it's a he, the architect. On SK8, they need to improve the line weights in the elevation. The setback floor is rendered nearly invisible. Setbacks are visible, so you need to actually show the line weight and clarify that the brick, which is being arguably provided on all sides, is continuous on the sidewalls and not only within the areas that are the subject of the waivers. So the notes have to be very clear that there's brick everywhere. I don't want to slip in of ephes when nobody's looking.
And I think to that point, a note stating that the facades, the entirety of the facade, something to that language.
Yeah, okay,
Even
so-
if the graphically it doesn't come through clearly, I think note would be more.
Okay, yeah, okay. Okay, also, a revised EAS was submitted on September 5th and 7th. I just want to know. if
Another
we're-
revised one yesterday,
Oh, another one? Okay.
and a revised set of plans, actually, that was submitted yesterday.
Oh.
It was late yesterday, and it only had 2 changes, just 2 notes. The notes are for the E designation for hazmat, and then the property to maintain a closed window condition
Okay. Okay.
with a minimum 35 dBA and an alternative means of ventilation to be provided, and that's from DEP's.
Those notes have been included in the plans.
And the new plans that were submitted yesterday.
Well, actually, the plans provided previously did show the 35 dBA window wall attenuation, but
It's
it
more
didn't say
detailed
closed
now.
window condition. Okay. So, relative to something we talked about yesterday, I want to clarify if, in fact, we're done with the EAS. I don't know. Do we have? We're done. We're done. Okay. So I want to, from now on, make it very clear in the hearings which date is the approved plan set, so that at the hearing, when we vote, we're going to be voting on a particular set of plans where we say dated as of X, submitted as
Yeah,
of
it'll be
Y.
according to the.
But this set of plans, anyway, you have comments that it needs to be revised again.
Yes,
So
right,
this
right.
one- the one
Okay,
was-
yes, so, but these are the kinds of things that they could do really quickly.
Yeah,
So-
I really hope they do.
Yeah.
I think that this,
The line weight is literally clicking a button on the drawing contraption that says, bring it up to another point. That's all you do. And then,
I think instead of doing the brick, it would be easier to just add the note.
oh, no, I'm not saying, no, I didn't say render the brick. It's just a note. So right now, the note says brick, but it's located in the hatched area of the waiver. It's just to add another note on the wall where you use these little arrows that point to the wall that says brick, right? So that takes a second. And you could also have the general note say brick throughout on the facade.
So we hope that they can do all of this today and we can
Yes.
vote.
So, and so I would like them to also, sorry?
And page SK8 that you said?
That's the
No.
one, we're improving the line weight.
That's the line weight.
Yeah.
SK8 is the line weight, which is a toggle on the CAD drawing. And then the question about the elevator is just telling me what kind of an elevator it is. And then, so what I would like to make sure is, since they are amending the drawing, that, and this is something for some reason architects no longer do, which is a really big problem, on the title block, there is a set of revision, there's a thing called revision and revision date, right? Revision number, revision date. That must be filled in with today or tomorrow's date, depending on when they submit it to us, right? then that will be clocked in. So we have our own stamp, and so we'll be able to say in the resolution, drawing prepared on such date, submitted to the BSA on such date, okay? So there's no confusion about which was the approved plan, because we've been having problems with the wrong plans being stamped.
And this is something we'll be applying going forward.
Forward.
Every
So,
project.
and if I forget, please remind me, everybody has to know which drawing very specifically we are marking approved, okay?
Any other comments on this application?
Item number 21, 2017-214A, 1459 East 24th Street, Brooklyn.
The demolition drawings were much improved, providing notes and clear delineation of existing exterior walls to be retained on the perimeter and totaling at least 50% of the walls to be retained and all floor joists to be retained. The front and rear attic levels are shown pulled back now, but not dimensioned. And the gesture of that pullback I find to be really slight, given that there's no real use for what turns out to be a 5-foot by 4-foot and a 7-foot by 5-foot space under the dormer, which I don't know what that's really good for, other than a very small chair for your very small friend. So that can easily be pulled back more on both sides to reduce the apparent mass. Inexplicably, there's also a large section of roof line that rises to 35 feet on one side, while the other side is lower but not dimensioned. All the heights and setbacks have to be dimensioned, and the roof should be at the uniformly lower height. Now it's just this weird lopsided thing. Just to be able to say we made it to 35 feet, I don't understand that. So, I mean, now from the front, the building goes like this inexplicably. And with this applicant, and let's say applicant's representative, the representatives always do this, they make a teeny little change, and it's almost like the exhaustion principle, and they need to make the change with full gusto, so we only do it once and not 4 times, right? So. Okay,
Anybody else?
that's it.
Is it?
Yeah,
Item number 20.
You wanna-
I just
you wanna
wanna
add some?
I
Oh,
just
'cause you
saw
looked at the
I just
drawing.
looked at the drawing, and the section where that bump out is happening, it's happening over the bedroom, which already has a pretty clear roof height based on the section, so not sure why that additional bump out is needed.
Yeah. I just think it's
It's already at an
politics.
8-foot high, so, and it fits in the rear. Granted, it's not going to be visible from the front, but then why do it?
Yeah,
The gesture is in the front, and you're already doing that, so I need it.
right.
And it's not adding to floor area, it's not adding to any storage space, nothing.
Okay, now move on.
Yes.
Item number 22, 2017-235BZ, 11-02 Supton Boulevard, Queens.
They requested an adjournment.
Item number 23, 2017-244BZ, 2208 Bowler Avenue, the Bronx. This has been administratively adjourned. They did not make a decision.
Right, so I just
Or
want
revise
to,
the application.
yeah, so I'm not sure what's going on with this. This is, has been in hearing for exactly 1 year, with the last hearing in April and the June hearing adjourned, which was the second of 2 prior non-consecutive adjournments.
I thought they were going back to, like, sort of revisit and see.
They needed a
Revise
new
it.
architect, and
all
Yeah,
that
but
other
so-
stuff, So,
The applicant, the rep, because it's Eric Blatnick, he really needs to come and explain what's going on, because when an application's not being prosecuted like this, what's going on? We can't keep this going indefinitely, right? So, and I thought that they had really arrived at a project, and now they seem to be unbuilding their, let's say, deconstructing their perfectly constructed project. I don't understand why they would back away so extremely from what I thought was a pretty finished piece of work, no? Yeah, it's just, it's confusing what's going on. Okay.
New cases, item number 1, 2016-4239BZ, 180 Manson Avenue, Staten Island.
Okay, we have proof of service of initial application to officials and of notice of hearing to officials and neighbors. Community Board recommends conditional approval stating that approves the application with the requirement that amplified sound of any kind, including music, is, quote, "at all times prohibited in the exterior of the premise or premises." There is one letter of objection citing parking issues and poor maintenance. And so with respect to that comment about parking and poor maintenance, I might ask then how many, in this little building, which was apparently an office, how many office workers there are currently in the building? Because it doesn't have a lot of patrons. I mean, there's only 70 seats in this building. So I'm thinking, well, if there were 30 office workers, then we'd have a sense of what the parking demands are, in other words, similar, right? And also, if there's a concern about poor maintenance on the site, could we make it a condition that this restaurant owner work with the marina owners to ensure that debris is removed daily from the site in general, so that it's well maintained? And then, I didn't really have any other issues other than the fact that there was one letter of opposition, but I'd like fire department to just take a look at it. There's lots of parking being provided around it, the direct access from the main road to the restaurant, so I didn't see any fire access issues, but fire department should take a look.
I'd like to know if that parking lot's being shared, because there's two
is
other.
being shared.
Yes,
It is
it
being
is being
shared.
shared.
And
I had some question. The statement of fact talked about that there's a lookout on the third floor. Just provide a third floor plan. They also need to confirm, similar to the issue raised by Community Board, the applicant needs to confirm that eating and drinking space, that no eating and drinking space will be provided outside on the wooden deck. That means people not taking the drinks and hanging out, because that's adding to the capacity. Even though there could be 70 seats inside, if people are hanging out, that's adding to the capacity, that's affecting the parking. So we need to ensure that the use of the space is limited within the walls and not outside of the wall. And the peak period, what is the peak period operation? And the hours of operation was not stated in the documentation. And the reason for these questions is, again, going back to understanding what is the utilization of the parking during the peak period, and if there are 70 seats and there's going to be 70 patrons, will it be able to accommodate it during the peak period? That's it, and that will address the concern that we have heard from the opposition.
Right.
Which I think it will, we just need it in our documentation.
Right.
They're saying they don't want their capacity to exceed 200 people.
200 people.
No, they only have 70 seats.
They have 70
70
seats, but
So
it says
then-
capacity not to exceed 200 people.
Okay,
That was
then
in
my
their
question is
statement.
even
So they-
more of where are they standing? They must be
Right.
then hanging outside with their, in that.
No,
in that area.
I think that's referring to the nature of the special permit. The special permit is only available, this special permit is only available if it's
okay.
less than
If it's
200.
less than, so they're just
Oh.
saying, okay, and we note that we meet that finding.
Yeah, we're meeting the
Capacity
findings
alone.
because we have 70
Yeah,
seats.
okay.
And it's a teeny little space, so it's not, they can only have 4 tables or 6 tables on these floors, right?
Perhaps the
They could
applicant can,
Hang out.
Well,
Right,
so
I
that's
was
a
thinking,
different
okay,
thing.
people must be congregating at the bar or something.
Yeah. But
maybe the
bar-
applicant tomorrow can clarify whether
Yeah.
they're making the statement for the benefit of the special permit or to further describe their operations.
But, okay.
One more thing, I'm looking at page 4 of the PDF. It's called page 9 on the drawing itself, and it's kind of an elevation for the building. Although it's an elevation, it shows some footings, and these footings are indicated to be 30-inch by 30-inch and 15-inch deep. And it sounds like just the depth of the footing is what separates the bottom of the footing from the existing grades. Looking at this elevation gives me the impression that the bottom of the footing, the concrete footing, is just 15 inches below grade.
But this is an existing building, so this might be like the architect just making it up. That's what you do when you're, you know?
You never know.
Right, because so I'm pretty sure it will clarify if it's an existing building. I don't think they're proposing to do more than decorate.
Yeah.
And because it's an office building currently, they're going to doll it up and turn it into a restaurant, so it gets,
If it's 15 inch, they have a condition that's not complying with the
Yeah.
requirements of the New York City building code.
okay, right.
So they need to check that. The building code calls for 3.5 feet minimum
Right.
frost cover, so they don't have that.
Move on? Item number 2, 2017-22 BZ, 16-45 Decatur Street screens.
Queens.
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 Queens,
Queens.
the Queens.
The Queens.
The Queens. This application received a dismissal notice in April 2018. I don't see in the file a response to that notice.
Yeah, they emailed it this, Rory
Oh, he
emailed
did?
it this morning. It was a May submission.
Okay, so
Yeah,
it
it's a
didn't
full
make it into the
submission, yeah, for
folder,
some
so
app-
I don't know what they
reason,
said.
yeah.
So we were reading old materials, so I don't know if the new materials say anything else. We do have proof of service of the initial application to officials and of notice of hearing to officials and neighbors. We do need a community board recommendation, don't have it unless it was submitted yesterday. We have 3 letters in support and Department of Investigation sign off. Fire Department signs off with comments. The statement of fact states there is no fire alarm system. I just want to make sure Fire Department is okay with that. Fire Department's comments are, a review of our records indicates that the above noted premise has a sprinkler system and the permit for such system has expired. A test order had been issued and subsequently the premises owners scheduled a hydrostatic pressure test for February 20th, 2019. So I guess inspection reservations take a long time, also at the fire department. The hours in the statement of facts has a typo. I think you mean Saturday 9 a.m. to 3 p.m. as opposed to 9 a.m. to hashtag. So, okay. Anybody else on this? Okay.
I realize it's 3 p.m. because I make that mistake.
Yeah, I know, that's how I figured it out too. I looked at, oh, look, what's this mean? What's going on? Stop it. It won't stop.
Always you, I'm sorry to say.
So that's the thing, how do I,
You're not disturbed.
it won't work anymore. I told you it doesn't work.
Can you unlock it?
No, that if I unlock it, I'm answering the phone. Take it outside, please.
If you bury it,
I'm so sorry.
Are we moving along? or-
We're moving along, otherwise I take the call.
Item number 3, 2017-288 BZ, 7-10 Whitestone Expressway, Queens.
Okay. We have proof of service of initial application to official and of notice of hearing to officials and neighbors. Community Board recommends conditional approval. They stated we voted unanimously to approve this application with the recommendation that traffic should enter the site from Petrarca Place and/or Whitestone Expressway and exit the site via Whitestone. There are 3 letters of objection, 2 from residents of 15th Avenue. The other one, I couldn't really place where they are, but it's probably right there also, which is right across the street from the proposed garage, citing concerns about lighting, noise, and air pollution and privacy concerns. The materials submitted by the applicant aren't clear about the proximity of this proposed parking structure to nearby residents. The site plan only shows the commercial super block and not much more else. There's a few little boxes that probably indicate those residents, but then it doesn't get into it like that. So to see if we can be as responsive as possible to the neighbors' concerns, given that this is an area with lots of parking garages and so on, I would like to see sections through the garage with cars sitting on the sections, both SUVs and other cars, and understand the headlight directions and the height of the parapet, which is quite low, where with the how the screening system will work relative to the tops of the cars and the deck lighting, including when the cars are on the ramps. We had another application like this where it was very close to residential, and when the cars were on the ramp, they shone right into people's windows. So, as opposed to when they were horizontal. And so we tried to initiate different kinds of screening. So anyway, this is more like show us that with the height of the parapets as proposed, because the parapets can be taller. There's no height restriction in terms of parapets here, I don't think. The parapets could be taller, there could be another kind of screening on you can still have it be an open garage where you have some sort of screening system in between as opposed to fully open.
No, like botanical gardens.
Yeah,
That
exactly.
garage, yeah.
Right. I mean, and I always go back to Miami Beach has the most beautiful parking garages. You want one of those in your neighborhood, right? They're beautiful, they're very important architects, they're covered in greenery, like there's so many solutions to make a parking garage desirable and also not notice that the cars are coming and going and all of that stuff, because, you know, you can say that the lights aren't shining directly in, but if you're aware of the sort of ambient light in your neighborhood all the time, that's also a form of light pollution, and I'm trying to appreciate what it's like to live across the street from this thing, where they've enjoyed, by the way, these neighbors, essentially a woods in front of their house. So the other thing that wasn't clear at all to me, when you look at the
Right, the
site.
parking lot's been in place for a
It's been
while.
there for a
Oh,
while.
it's
In fact, now
at
they're
grade
actually
parking.
gonna.
No, the
No,
parking
the full
garage
structure
structure
is
is
already
there.
there.
Oh,
They
it
just
is?
want the roof to be
Oh,
allowed
I
parking. But
see.
right now,
Okay.
the whole thing is in existence. In fact, now they're gonna actually plant screening in front of it at
Right,
least, where it
okay.
was open.
So, but
And this
I-
was never
I
a
thought that
wild
it was a
space, because
different-
this is part of the College Point industrial area. These were always these always had been used as various office spaces, parking spaces, and so they were always, this space especially was always a very concrete area. So I just want to be clear that this was not that part of the College Point that we see in the middle of the 20th Avenue and the southern section of it. This was the only section of College Point industrial area where you had development and office spaces, and all of that has been allowed. And many of these office spaces, all of them have their garages mostly facing along 15th Avenue, and they are actually, some of them are even closer than what this proposed one is. This one has a much more setback.
This has a 60-foot buffer
It has
on a 50-foot wide
Right,
street.
and it has big boulders and other things, whereas some of the others are right almost
Right.
on the property line. So there's a big difference between this existing garage that is before us and some of the other ones that are already there. That is
I'd like some more
But I have a
pictures so I
question.
can understand that. I'd like
Sorry?
some more pictures.
Yeah.
Because I didn't
agree.
really
You have to
get
go to the
that.
site
Yeah,
to
you have to go to the
understand.
site and go into
go
the
into the-
other parking
Right.
lot of the school.
Which is right next to it, right?
Yeah.
And the proposal is going to use the entrance from Whitestone, while from the Petrarca place can be used, and it is used, it's like an industrial park, so there are a lot of other businesses that are off this Petrarca place, and they are using it, and there is a possible way of accessing it, and if it can be done, that's great. I think it would be better for this project because Whitestone Expressway Service Road does get backed up during morning peak hours. And I think that this can also reduce some of the backup onto the Whitestone Service Road during morning rush hour and evening rush hour if you allow the access from Petrarca Place. Not to say that 20th Avenue is not backed up during all periods of time. So I think you need, that needs to be thought of.
Right.
But there is no way that Petrarca Place, there is a gate of Petrarca Place off 15th, but that has been, as far as I remember from this site, from my days back at city planning, has never been open.
It's
It
sealed.
was always-
You
yeah,
don't
it
go
is.
through, I mean,
Right.
it's not in use at all.
Right, it's kind of like an emergency access way, it's always been gated. Every time I've gone to that Target store there and all of that, it has always been closed.
So you're saying that the site already, I haven't
Has
been to
a-
this.
has the
The
garage.
garage is already in
Yes.
place?
Yeah.
Even though the 2018 satellite shows nothing there?
But it's in.
There's a
place.
garage
I was
there.
There's a garage on the side.
Yeah,
Oh.
there's a garage on the side, I was there
Where do I
last
do
week.
that?
And so was
It
I.
doesn't always-
In fact,
Yeah.
they're now building the landscaping, the
Right.
screening in that 60-foot buffer area right now.
Yeah. 17, oh.
1710.
No, but it's the same. It's a site. It's a site. So,
Yeah, actually, the garage is here. It has been built.
no,
Is the
it's here. Sorry.
We just, they,
Anyway, but what I wanted to say is, there is that buffer space that's shown on the drawings badly, that, because the drawings are really hard to read. That's like the 50 or 60-foot wide buffer, and I'm wondering why that couldn't be more fully planted. Like, instead of just that little strip of plants, why they can't just plant it up deep densely, so that you've got, like we've seen in some of the other old BSA projects, where you just turn that area into sort of like a primordial forest. You just plant it and let stuff grow there. Then you'd have both sound and noise buffer, and you wouldn't be relying on just this little 8-foot depth of trees.
Can I make another
Yeah.
suggestion? This is from the building that I live in. We have a 5-story garage, which is facing a residential building. And the way we have buffered the garage is we have these poplar trees that are lining along the parking garage all along. And they have become very full. And they go up pretty much four stories or so. And they create a very nice buffer and screens the light and the headlights from the parking. I can provide a photo
Okay.
just to give you an idea.
But they're not really leggy, like long
They're-
trunks.
I have to show you.
Poplar
the-
usually has a long
It
trunk
does,
and
it
then
does, but
high
it
branches.
does, but it goes up to about 8 feet, and that's where the solid wall is, and after that, it starts spreading out, and it almost blocks it. So I can show you the photos of
Yeah,
my
but
garage.
I mean, these are little
conifers
houses.
Sound like they're going to do a nice job.
Yeah.
Because they're going to be 30 feet and they're,
Right, because what you
12
really
feet
want
apart,
here
yeah.
is not the poplar idea, which is the long and then a branch, but the Christmas tree idea, which is a peak at the top that's very tall, and then it opens out, and when you don't maintain them, they're even better because they get bushy at the top, right? So you get bushy all the way down to a very short trunk. Because in this case, you've just got 1-story houses or 2-story houses that's a completely different thing than buffering for an apartment building. But the reason I was asking why the buffer can't be just more planting there is because it doesn't sound like it's being used for anything, and why then you would get more benefit of the sort of the dense shrubbery on the edge, and then the thickness of shrubbery going back further into the forest, so maybe you wouldn't even notice there's a garage there anymore. That's why I was asking about.
so they said they're closing every day at 6:30. So my question is, will they at least turn the lighting off in the garage since it's going to be
Right.
closed? And that would also really help if the garage is then dark all
Yeah.
night long, then we don't have to worry about headlights or actually
Right.
their own sight lights at that point.
Yeah. Well, that was a question I also had in terms of the lighting. So they're showing, because it's the easiest way of doing garage lighting, these rooftop stanchions that are very tall. And then they need to direct the light cone so that it only lights the top. But there's many ways to light a parking garage. You can light from the parapet walls themselves, from the level of the cars themselves. I don't see any reason, and in terms of security, you still get security there. You can also use those low stanchions that are midway, and they light up at that kind of level to make people feel comfortable. And anyway, it's close to 30, so in the winter, you have 2 hours of darkness there. So I'd like them to look at a lower lighting system. And then the other part, I have a question, which is about the interpretation in the zoning resolution, which is, to what extent does the zoning resolution allow you to increase the size of the group parking facility beyond the 225 spaces when 237 spaces are what's required, and you're now opting for accessory and saying, I can have up to another 225 spaces, because it's like a disconnect between the two
I have the
sections.
same question, and I read the regulations with regards to what is the, how it's being applied, and what we are waiving. What it's saying is that zoning regulation permits maximum of 363 parking spaces, and
No, zoning resolution permits for accessory, non-required parking up to 225.
225
If
spaces.
DOB agrees with you, kind of
Right.
thing.
And, hold on.
But then they're required, under the math for their office building, to have 237 spaces.
237 spaces, that is 1 per 300, that's the math that results in 237 spaces. But it's saying the zoning is also permitting more than that 1 per 300 spaces. So it's the total of that and the 300.
That's what they're saying.
And that, to me, is a kind of, I don't think that's how the zoning was meant to be interpreted. My understanding is that, yes, it says the 4412 says maximum size of accessory group parking in all districts as indicated. No accessory group parking facilities shall contain more than 150 off-street parking spaces except as provided in section 4413, which is the modification of maximum size for accessory group parking. And then it says exception to maximum size of accessory group parking facilities under section 4414. It says in all districts as indicated, BSA may permit access to group parking facilities with more than 150 spaces in accordance with the provision. 4420 has the required accessory parking spaces, which says, the 1 per 300. So I don't think the 150 is the reason for the 12, which is maximum accessory group parking. It's putting a cap on it, and if the 1 per 300 exceeds that cap,
I think it should be done.
you should be done. I'm not sure it's meant for you have the maximum, then you add the 1 per 300.
Right.
That's not how I understand the text to be written. I would like the applicant to explain where that read is coming from, because it goes from the general and then to the specific. It's setting the cap, and then it's saying within that cap, you're allowed this much.
Right. That's the way
That's
I
how I
read
understood
it.
it.
And the applicant, in their statement of facts, tried to make an argument which was sort of all over the place. I never followed their argument. I only followed their conclusion. The conclusion was, therefore, we can have it. But the,
Yeah, and
And
Yes.
also provided a case, a BSA case, 74-93-A.
I know
where
you
this is
stated
discussed
it, but I
on
can
page
understand it.
12.
yeah, they discussed it, that there was another case, but that doesn't mean that that's the way the DOB, I would like to know, how does DOB interpret this? Do they really allow you to do that? Because it's true that there are sites where you have to have 3,000 parking spaces. Does that mean I can have 3,225 parking spaces? It seems, quite an imposition on everybody that you would do that. And then in terms of this, I also don't really understand the reason for having more parking spaces. They're saying there is a demand of 200 spaces when they do the analysis, but meanwhile, they're providing 237 spaces as required, but they are proposing 360 spaces. So why are they providing 160 more spaces than demand? Like, what's going on? Is there some indication? One of the comments from a neighbor was that the parking isn't actually used on the site extensively. I don't know if you saw it was heavily used on your
Well,
site
that
visit.
parking garage right now is vacant because the building has not been built. But the other parking garages affiliated with their respective office buildings, they're utilized. I couldn't say from outside, they were fully utilized.
Yeah. So, and I understand the assumption that everyone drives to work.
Yes, because
That's-
it's not
that's
close to any
fair.
transit.
But then if everyone drives to work, I don't know how many workers there are in this office building, and if utilization under zoning is the 237 spaces, how
I think
does,
this affects our special permit requirement and how we are analyzing the environmental review, really.
Yeah.
That's really it
Yes.
comes down to. Because right now, per environmental review, all of this is permitted as of right. We're just waiving the rooftop
Yes.
parking. Whereas this would require a whole set of environmental review if you're exceeding the 150.
Right.
Which is,
Yeah, exactly. But the rooftop parking makes possible another 53 spaces, or whatever the number is.
58.
58 spaces. So, so you could say, why do you guys need those 58 spaces?
I think they did cite that this is an area where, this is a facility where I think a lot of the employees will be coming for training and programming, and so they needed to make sure all of them could, and they'll be coming from various facilities and will be parking there, and therefore,
Right, but
allow
they
for that.
didn't quantify it. That's why, so I didn't make the connection between people coming from other places. Sure, that's how offices work. You have visitors, you have meetings, you have all of that stuff, but they didn't substantiate it in any way. And if this is an existing business, then they know this without doing an elaborate study. I'm not saying they need to go out and do a study of how their existing businesses work, but the business owner knows, we have an office currently that has 150 workers, and on a given whatever, we have this many visitors. And then that could easily back up their demand. Anybody else on this? Okay.
Item number 4, 2018-61BZ, 620 DeGraw Street, Brooklyn. This is a PCE.
Yes. We have proof of service of initial application to officials and of notice of hearing to officials and neighbors. Community Board recommended conditional approval stating that the operator should work with the adjacent business owners and the Community Board to help alleviate illegal parking which affects deliveries. I don't understand what that has to do with the Goldfish.
It might be because this is an M12 and its neighbors are businesses that need deliveries, and maybe the use of this space is obstructing the street. people
But it
illegal
doesn't,
parking.
it's not a legalization as far as I know.
No, it hasn't been built yet.
Yeah. So I'm not, and then also, I just want to say this because the Community Board wrote us a little note that we acknowledge. Community Board wants to advise us that it should be noted that during the committee's discussion of this application, a hope was expressed that the Board of Standards take into account the ongoing planning process of the neighborhood-wide rezoning when evaluating future similar applications in the Gowanus area. And so, though I don't know what they're getting at, we welcome very much the Community Board more articulating their concerns, happy to meet with the Community Board, all of those kinds of things if they have something in mind, but at the moment, that was so cryptic. I don't know what we would do if we saw an application. So we have 3 letters in support. I'd like the applicant to confirm, though Commissioner Ollie Brown just did, that it's not open. We have DOI sign off. The statement of fact states that the C of O shows an existing fire alarm and sprinkler system. We need fire department to comment on if there's any issues, though the space isn't there yet. And just as an aside, I went onto that website of the neighbor, and I have no words for what happens there, but I recommend that everyone check out what goes on. It's called kickaxe.com, and I hope that the Goldfish parents are okay with the contrast in use. So, it's like little kids swimming in the pool, and then you can go find out what happens at kickaxe.com. Anybody? Any other comments?
Item number 5, 2016-4335BZ, 220-21, 137th Avenue, Queens.
We have proof of service of initial application to officials and of notice of hearing to officials and neighbors. Community Board recommends disapproval, citing lack of customary rear yard and customary separation from adjacent lots, overall bulk, and that the 25 by 100 lot, though undersized, is not unique. The Community Board letter appeared not to have as strong an opposition to a one-family home, which is not here proposed. And I was just kind of reading into that because they sort of said that as an aside at the end. We have letters in opposition from a number of electeds. Assemblymember Alicia Hindman State Senator Leroy Comrie, and Councilmember Donovan Richards, all citing neighborhood context, strain on parking and services, the predominant concern being the absence of the typical yard space. The applicant, just before to get going, the applicant needs to show that the property has been owned since 1961 independently of other adjoining properties. That wasn't provided, and we really need that. So essentially, the ACRA search. One problem I have with the community's opposition to this application, and by the way, we're required to comment when we don't agree with the community board's comments. So we're required by recent local laws. So one of my problems with that is that a formerly standard narrow lot has been rendered substandard by rezoning, which has deprived the property owner, assuming the property owner doesn't own adjacent lots, of any reasonable use of the property. That is known as a taking, and that is what the Zoning Board of Appeals was created to prevent. Unfortunately, the zoning resolution isn't nimble enough to address this kind of an issue, and the BSA is often presented with these quandaries. Often, the solution is a home with dimensions that are similar to what is being proposed here, although we do see small front yards along the long frontage, and that could actually be done here in this case. This proposal's 137th Avenue front yard lines up with its neighbor adjacent, so is in context. The neighbor adjacent has a 5-foot side yard, while the proposed has a 3-foot side yard, and both of the proposed side yards comply with the zoning resolution and provide the minimum distance between the houses, so I'm confused about that objection by the community. My other problem is that two-family homes are permitted as of right in an R3X, so I don't understand that objection unless this would be one of only a few in the neighborhood.
Which it is not.
Which it is not. So there's a study provided that shows there are other two families on the same block and many, many in the 400 to 1,200 foot radius around the site.
Is the
With respect
neighbor-
to the A finding, the area study states that there are two corner lots in the study area measuring 25 by 100 that are developed with a 17-foot wide and a 16-foot wide house. I don't, however, see the backup chart or map for those conclusions. Maybe they were there,
They
but I didn't find it.
they submitted quite a detailed neighborhood.
But I didn't see those corner houses with the 17-foot wide house articulated or shown. I couldn't find that. I did see that they submitted a bunch of studies. But what I want to say is, since those lots apparently have viable houses at 16 or 17 foot wide, why can't a narrower house be developed here that provides that front yard, provides a front yard? Providing the full 10-foot front yard would make this not a viable house. And for example, the house immediately next door is also very narrow, so what about a house kind of like that one? The front yard study shows that a 0 front yard would be atypical in the study area, so I do think a front space of some depth should be provided. I don't see that the study that they provided tells us what the ranges are, even though they submitted a report, but a written report that says the ranges are, whatever it was, 5 to 10 feet or something like that, but they didn't actually provide us with the maps that show that. With respect to the drawings themselves, the elevations have to be in NAVD 88, and maybe they are, but they need to indicate that. With respect to the driveway to that little accessory site, accessory parking space, I don't understand how you get to it. The driveway's right in front of the garage, but I don't see how you make it over to that other little spot. And with respect to the FAR, I don't see the need for more floor area, which is only 180 square feet, but anyway, since the issue is front yard compliance, not floor area, so they should take that out. Any other comments?
The data that they had provided, which I was looking at, and they did an analysis of 400 foot and a 1,200 foot. So I'm referring to the data that was done for the 1,200 foot radius. And from that, it seems there are 9 corner lots that are less than 25 feet deep. And many of the
2,500 square feet.
the lots are less than 25 feet deep, 25 feet deep.
Deep,
And they are-
25 feet deep.
And they do have developments that pre-existed the 1961 regulation. So though these buildings are non-complying, the second front yards, some have it, some don't. And on an average, they're about 5 feet or so. So that's kind of the number I saw, so that's some.
So, okay, so you found something that shows the 5-foot depths of, or you're guessing 5
No,
foot
no,
deep?
there was in the, I can't bring it up, but I
Okay.
did look at it, and it seems like there was some amount of front yard. In situations where it was provided, there was,
Right.
it was a maximum was 5 foot, so maybe something in that range can be provided.
Right.
And based on the site visits, I did see there were, within the immediate area, there were lots of two-family homes.
Oh, yeah.
So I think it would be helpful. I didn't see any documents to that effect, maybe they.
Oh,
did
no,
provide-
there's a really great series of maps that show
missed
you
that.
all the two-family homes. There's a
Okay,
lot, there's a
I
lot
missed
of them.
that. But, okay, so then that
Yeah.
answers my question.
I mean, there's actually a great series of maps that shows you all the narrow lots.
Yeah.
But then I didn't find more information that gets me to how big the houses are on the narrow lots, or how big the yards are in the narrow lots. That's what I couldn't find, and maybe because there were several submissions. And so we open what we open, and maybe we think, oh, I looked at that one already, but maybe I didn't look at that one already, or something. That's part of the problem with piecemeal submissions, but anyway.
I had a similar question about the e-finding, why 22-foot wide home? So what's the predominant building width of the corner homes in the area? And what's the average width of the homes in the area? And why is the extra floor area needed? Also, why not just yard waivers?
Right. Anybody else? Okay.
Item number 6, 2018-3BZ, 154-160 West 124th Street, Manhattan.
Okay, we have proof of service of the initial application to officials and of notice of hearing to officials and neighbors. Community Board recommended approval with 18 in favor, 13 opposed, and 2 abstaining, so it's effectively 18-15, which is a very close vote. I would like to hear why so close. The Community Board recommendation doesn't articulate its reasoning or discuss, have minutes. They should clarify, the applicant should clarify that the transferred development rights can be transferred across district boundaries as of right. That wasn't stated in the statement of facts. It needs to be clarified. With respect to the A finding, this needs a lot of work in the statement of findings, which seems not to know what cases it should be reciting to, or seems not to understand the cases. First, merely being a not-for-profit is not sufficient to have an A finding, nor is being a not-for-profit with programmatic needs. Columbia University received its 2006 variance because it benefited from the doctrine of educational deference under the Cornell v. Bagnardi decision. This application has to tie the educational aspect of the program, which is extensive, to the deference argument. I'm concerned that the applicant's counsel doesn't understand the decision in Cornell, and I hope that he or she reads the actual case as opposed to reading excerpts of it from the BSA decisions. It's very important to understand educational deference and how that applies to this case, and to apply it appropriately. And if you need help with writing that argument, we have many examples by other attorneys that cite to Cornell and its progeny, and that should be used, because I was pretty disturbed by that statement of findings that was all over the map. So in terms of the A finding. Also, and the presence of an existing building on the lot, just to keep going on some of the misunderstandings about the A finding, the presence of an existing building on the lot or an obsolete building is not at work here. You don't have any, so in the Guggenheim case, the zoning lot that contained the Guggenheim Museum was constricted by the museum building itself, and potential for development was relegated to areas that were not feasible for as-of-right construction. And in terms of this existing garage building, it's not its obsolescence that's driving the waivers at all, right? It's not that you're saying you can no longer use it as a garage, therefore we need a variance. You're saying, I'm building an educational facility, a medical educational facility, and I get deference. And then that ties into my programmatic needs. So now moving into the program, I'd like to understand better how the high school program functions at the first floor to keep the children separate from the adults. I don't see a separate lobby for them at all. Does the high school take up the entire first floor except for the lobby and elevators? It apparently does that, but there's no separate lobby. And the 13 therapy rooms at the first floor, are they actually all for the high school? Like, how does that really work? And are the classrooms used after hours by others? I just need more information on that, wasn't explained. And what is the concept behind co-locating a high school here with the health facility? Is it that the faculty are actually also therapists who work in the facility? Is it an opportunity, a teaching opportunity to be working with children who have these kinds of issues? That needs to be explained better. No separate programmatic needs analysis was provided, so there's nothing to support the plans that show how the program works and the need for 31 private therapy rooms on the second floor, 24 private therapy rooms on the third floor, 19 private therapy rooms on the fourth floor, 14 private therapy rooms on each of the sixth and seventh floors, and 14, and then I understand better the exam rooms and the dental clinics, but how is it determined that you need to have, say, 14 exam rooms and 7 dental clinic stations? I mean, so if the applicant were to look at a programmatic needs analysis for a hospital, the hospital gets into enormous detail about why you need to have X number of operatories, how the operatories are paired with recovery rooms and all of that. Whereas here, it's very unclear how each of this total count came about. And the total count drives the waivers, right? If you don't need 31 private therapy rooms, maybe then you can have a setback. So that's what we need to understand in order to let's say, establish that that programmatic needs are actually forcing the envelope of the building to be bigger. The applicant needs to show the overall building depth on the floor plans and improve the exterior wall line weights on the PDFs. The wall lines more or less vanish. They need to indicate on the plans which floors are within the existing building envelope and which are completely new. So that has to do with rendering existing walls versus new walls clearly. With respect to the building design, and I don't know if, so with respect to the building design, I really think it's a shame that the clear grand entrances to the existing building are being bricked up and their arches and rondelles relegated to mere pastiche. Each of these would make a perfect and clearly distinct entrance to a high school and to an important medical facility. In general, the entire facade treatment is disrespectful of the existing building's Romanesque revival facade that still has intact terracotta detailing, unless the intent is to completely reclad it, in which case it's disrespectful also, but then it's a reclad. There are really good buildings on this block, and a new building should treat the block with respect. So there's actually a beautiful Gothic revival warehouse building right across the street from this. So, you could take advantage of this great structure and enhance it rather than kind of debase it by bricking up the arches and so on. And then another question that I have, so they're showing rooftop mechanicals and penthouses just stuck on the roof behind very unconcealing parapets. In fact, I think they're more like railings. So I'd like to see them conceal the rooftop mechanicals and penthouses better. And since we're waiving height and setback, you can actually put up a screen that exceeds the parapet height maximums. And then as long as we're talking about building design, since I'm talking about building design, but with the understanding that I see that permits for the base building were already issued, and perhaps on the interior, the work has already gone. Have you seen that there's demolition on the interior?
Well, I did notice that there were workers milling around this building.
Milling. Milling isn't the same thing as sledgehammers and
I didn't go
Well, the
inside.
scaffolding is
The
up.
scaffolding is.
scaffolding, so,
Yeah.
so this is hoping that the work on the interior hasn't started. The interior work that I'm referring to is the removal of the existing joists. So this existing building was built to carry the weight of automobiles with heavy timber joists. That's how stuff was done. You cannot get those timber joists anymore. They don't exist. And thick masonry walls. I'd be surprised if the walls aren't 2 feet or even 3 feet thick. I don't understand why anyone would want to remove such incredible structure. And if that's what it still is, it could have been changed since, but, why would anybody remove this for a parking garage? So I assume it's still the timber joists in the original masonry beam pockets, like, wow. And I don't understand why anyone would want to remove them and replace them with contemporary materials that are not nearly as good. Further, altering the floor-to-floor heights affects the windows and forces realignment of the window openings. All very, very costly work. And if the reason for doing that is merely to get an extra floor into the project, then I personally wouldn't object to this building going 1 story higher to compensate in the interests of reusing existing structural systems. From a neighborhood character perspective, I could justify it. There's already a 10-story building across the street that rises without setback for 10 stories, a 6-story building that is effectively 8 stories without setbacks because it has very high floor-to-floor heights, because there were a lot of sort of warehouse buildings on this block. And also a 12-story that sits back at the 8th floor. So you've got lots of street wall buildings that are very tall. And as stated in the statement of facts, the existing building already rises to the height of the adjacent buildings at the rear, so the additional damage sort of impact on them is say less as it goes higher. I don't know if all this is too late. I wish it's not too late because it's an extraordinary building, but, we do.
I have a question.
Yeah.
You asked about, you raised the concern about removal of the timber joist. Given that this is a medical facility where, as I understand it, there are lots of heavy machineries used that are vibrating and other things, and while these might be very solid things, I think programmatically, why is it so critical that the timber joist be regained? I mean, and how does it relate to the special permit that's before us?
Oh, no, so I'm talking about, they're coming in to us, it's a variance, right?
It is.
Sorry, it's a
So they're coming into us for height waivers, right? So I'm like, you're already here for a height waiver. I could justify more height. It seems to me that what happened at this building is when the architect was first approached, their programmatic requirements might have been 5 floors. And the architect said, well, the envelope of the building will accommodate 5 floors if you guys are okay with 11.5 floor-to-floor heights. So I'm going to drop down the floors to be 11.5 floor-to-floor heights. Then I fit within your envelope. I can take advantage of a non-complying building, which is common.
Yeah, I get that.
And, right? So and maybe at the time, when they first started, they looked at doing this as an as-of-right project where maybe they get 1 more floor and that one has to comply with the first setback requirement. And so we'd be okay. And as they started to look at it more, they realized no dental, no this, no high school, et cetera. So as the program expanded, they said, you know what, we really need a variance. So I'm thinking that they got onto this path of changing the floor-to-floor heights because that's the path they went on. But that the idea that you would take very, very strong structure, and this is also me speaking from the point of view of a preservationist and sustainable design and all of that stuff, where you're trying to reuse existing buildings and not throw out perfectly good material in favor of not as good contemporary material, which is a fact, right? So what it has to do with is simply trying to make a better building. And if they have a reason why taking out the joists works out better. For instance, I saw there was a violation for cracked joists. But a cracked timber, these timbers are enormous. So to have found cracked timber, the way you repair those things is they put these steel straps around them, and then they last for another 100 years. So, the idea of going from, unfortunately, our contemporary materials are not as good as the materials from 100 years ago. So that's what's driving this. It's not that they don't have the right to replace it and all of that, and that they, it undoes the variance if they replace it with new. It's that they shouldn't need to. And it's not about cost. This is different than if this was a for-profit, where we'd be saying, why are you spending all that money to gut renovate the building when you have this building, right?
So it's not something that we're requiring.
No.
them.
I'm saying it's just I'm saying it's a shame. I'm looking at also the design of the building, where there's these beautiful arches, and they're bricking them up, and they're putting in this glass facade, and so the arches will look pretty lousy. And meanwhile, you have two uses. You have a medical facility and you have a high school, and at the moment, they're sharing a lobby, when clearly those two entrances would be grand entrances for two disparate uses. So there's a lot going on with that. Did you?
I had some questions as to the programmatic needs. And it could just be that it was a lot of reading and I didn't quite get it. But, it seems to me that a lot of the conversation was about how these uses are being evicted from their current spaces, and not any conversation about whether or not there are critical adjacencies that necessitate that all of these uses be in this one building. So I don't know if I missed it and it's there, but that's what I would like to see, because it's not just a question of, we have 26,000 patients a year, and so therefore we need all of this, but also talk about what in the program necessitates that children have to be at this site, adults have to be at this site, that HIV has to be at this site along with mental health, and a discussion about all of that and how they're all related. It could even be that the educational portion of it with the medical students and residents necessitates that they all be at one site, and that's why all of these things are around there. I'm not sure, I'm just wondering. So more information about that would be helpful. And then I read on page 10 of the statement, when they talk about the Mount Sinai Ambulatory Behavioral Health Center, they talk about the different programs that are involved, and one of them is a partial hospitalization program for adults. And I was wondering, are they having any adults reside here temporarily? And what is this program then, partial hospitalization? Because that seems to me to mean that people stay longer than just coming for a visit. So if they could just clarify that, that would be helpful.
Okay.
Commissioner Otley Brown raised the same question that I had, which was that while they're relocating, it wasn't clear, A, if they had looked at alternate sites where these could be located, and why it was necessary for these particular programs to be relocated under the same roof, and what are the common elements that's tying them together. That was one of the questions. I also had a question, which was it talked about, with regards to the as of right, it said the applicable requirement of Article 28 of New York State PHL, that would result in special loss, but it didn't say how the regulation would result in a special loss of programmatic space in an as of right building, and for which the proposed footprint was required, or enlargement was required. And that was
Right. Well, and to pick up on both of your points, one of the statements about why the as of right doesn't work is because it's a loss of critical adjacencies, but then it doesn't tell us what the critical
What those
adjacencies are.
Right.
And it also, it says that it would create duplicative functions, but it doesn't tell us what is duplicated. And we have, just by way of education, lots of really good applications that have been prepared by other hospitals that talk about these identical issues, how many clean and soiled rooms there are, how many nurses stations there are, and that kind of thing. And as you repeat floors, that you have to have more staff, more nurses stations, more clean soil rooms, more
ratio of
state.
staff.
Right, it's the ratio of staff, it's more sterilization, it's more travel between all of that. But here, we don't know why it matters that there's more travel between. Whereas in those other applications, we learn a lot about how terrible it would be that the nurse has to travel 4 floors in order to get to the patient. Or sometimes it's things like the patient's in such a bad way, and the idea of making the patient get in an elevator and go to another floor, they leave. So I don't know if that's the situation here, but the idea of keeping the adjacencies on one floor so you know that the patient goes from this kind of treatment to that one, to that one, to that one, escorted by the nurse, then you know that at least when they leave the building, they've been properly treated, that kind of thing, right? So, any other comments about this?
Yeah, just very quick. I agree with you regarding the, like, the alternation of the floor heights. I would love if this project is still in the beginning and they can, like, let us look into, like, granting a taller building instead of, like, them moving around the entire floors, 4 floors, I guess, or 5 floors, to just add 1 additional floor. The other thing is, right now, they are heading for, like, entirely waiver of the setback along 124th and at the rear of the building. The as-of-right scenario that they looked at, it's a building with a smaller floor plate for the additions. I'm wondering if there is something like in between, not just like entirely waiving the setback on the front and the rear, nor eliminating this waiver at all, like something in between with intermediate floor plates, and without playing around with the floor heights, we could look into something like that, probably.
So in other words, a lesser variance,
Yes,
right?
yes.
So the lesser variance is driven by the program. So,
Understood.
right, so like we had another application where what was sitting within the waiver area were some offices, right? We had another application like that. And we said, why do you need the offices to be there? Put them someplace else, right? So in this situation, because we don't understand what the programmatic requirements are, we don't understand that they need 14 therapy rooms here and 19 therapy rooms there, we could easily say
Yes.
ignorantly, what do you need so many therapy rooms? Combine them into one, pull it back, get rid of some therapy rooms, because we haven't been given any data or any method upon which to say, oh, we see why your floor plate needs to be that big, right? So I think that's.
Yeah, of course, I meant looking into this after tuning up the programmatic needs and looking into it one more time.
Right, okay. And then, Commissioner Shavetta, do you have?
I have
comments?
nothing on this.
And then the
Nothing
only
else
thing
on
I
this.
wanted to point out, this is an EAS-related thing. There is an individual landmark church located catty corner behind this building at 147 West 123rd Street, and the EAS states there are no sensitive receptors for shadow studies, therefore doesn't do any. I want to make sure,
We did receive LPC sign off, but because the SharePoint was being weird, I couldn't upload it to.
Oh,
the user
okay.
site, But it is in the next round, it's in SharePoint, so the next round.
Okay, but I just want to make sure if LPC signed off, did they sign off for shadows? Because shadows are based on sensitive receptors, and I read the designation report, and it talks about, quote, impressive stained glass windows. And when I look at the apps, it looks like there are stained glass windows at the rear of the building. And so, in which case, those are receptors that, and also there are these towers, which I understand have stained glass all the way around. So both of them would be affected by the height of the building. And then in addition, which is stated in the EAS, because the the landmark is within 90 feet of the subject site, the subject project must file construction protection plan, and if they've already started construction, which they apparently have, they must have filed a construction protection plan, which I did not see on the DOB website. So I want to see that it was filed, that they made one, and that they coordinated with LPC about it, because that's very important. Because in order to add more floors, they're going to have to drive some kind of footings, whatever, right? Or something. Well, on the other hand, they're resting on top of these 3-foot wide walls, so maybe, I don't know.
Maybe they are using the same supporting elements that existed.
Yeah, right,
before.
so maybe not. So maybe the vibration isn't as much of an issue against that building, but that's an LPC thing that,
It's a very challenging project. I don't know how they thought about doing something like that, moving 4 stories, moving them like 2 or 3 feet up and down. It's
right. Well, we see gut renovations in envelopes all the time. I just think, my God, it helped cars, for God's sake. If I think about how much, not that they have radiology department here, but I mean, if you think about radiology equipment, I don't think it's heavier than the car. So, all right. Any other comments on this? No.
This concludes the public review session for September 12th, 2018.
Okay. Thank you.
Long day tomorrow. Not super long.
No, 1 o'clock. Spring is broken. So 1 o'clock.